30,000 plus case law. All legislations, trusted by thousands of legal professionals and law students. The future is here. AI paths, faster, smarter legal research.
Sierra Cables, where innovation and excellence are at the heart of everything we do. Our state-of-the-art manufacturing facility in Kaduela is equipped with the latest technology, allowing us to provide cutting-edge power cable solutions. We take pride in introducing our fire-retardant cable range, designed to meet the most stringent safety standards. Our commitment to safety extends beyond industry norms. We host a high-end laboratory at our premises. Sierra Cables, where innovation, excellence and safety converge to power the future.
It's your love that has lifted us here. Thank you for making Maliban Sri Lanka's most loved brand for the second consecutive time.
Hassle of managing company transport and logistics, drowning in petty cash and receipts? With Pick Me for Business, simplify it all with one comprehensive digital solution built to suit your needs. Gain complete transparency on expenses with detailed trip reports tracking every cost, every time. No more manual handling. Digitize petty cash and let employees book through a corporate account with real-time department-wise reporting. Need variety? Our comprehensive fleet has it all, from delivery bikes to vans and trucks for bigger logistics. Take care of your team with overtime meals and rides anytime, any place. Reward your staff or boost promotions with weekly vouchers and explore flexible rental packages for long trips or airport pickups. Get the big picture. Live trip tracking, scheduling options and budget controls by department, all at your fingertips. At the end of the month, choose easy prepaid or postpaid billing and get round-the-clock support from our dedicated account managers. Pick Me for Business. Streamline your corporate mobility, logistics and employee rewards. Let us take care of your travel and logistics so you can focus on what matters most, your business.
Why real energy? For passion. A competitive spirit. For life on the move. To work hard and play hard too. Real energy is for the night owls, the hard workers. It's for those who do and want to keep doing. Right. Real energy.
Good morning, everyone. As I welcome the distinguished panelists and all of you participants, I would like to briefly give a small overview of the session before formally introducing the resource persons today. The Junior National Law Conference 2025 is built on the theme Raise the Bar. Today we are gathered to reflect on a fundamental tenet of our profession, that justice must never be a privilege reserved for the few, but an accessible right open for all. This session and the key speakers would explore how junior members of the bar can play a transformative role by engaging in legal aid or pro bono, as we generally say, work, whereby such work would develop the skills, networking, and exposure of a young lawyer, enhancing their career aspects. Our first distinguished speaker is His Lordship Justice Sohitha Rajakaruna, a sitting judge of the Supreme Court of Sri Lanka. Prior to being appointed to the Supreme Court, Justice Rajakaruna served as a presiding judge of the Court of Appeal and has acted as a president, Court of Appeal on several occasions. Justice Rajakaruna's illustrious legal career spans nearly 3 decades, including his service as Senior Deputy Solicitor General and Supervising Officer of the Civil Division of the Attorney General's Department. Justice Rajakaruna holds a master's degree of law from the University of Colombo and has furthered his professional experience at the National University of Singapore and the University of Deakin in Australia. His Lordship is a published author and has also actively contributed to the development of the atomic energy legislation in Sri Lanka. In addition to his judicial and legislative contributions, Justice Rajakaruna has been a visiting lecturer on constitutional law and frequently lends his expertise to academic and professional institutions. His Lordship Justice Sohitha Rajakaruna, over to you, sir.
Distinguished members of the bar, esteemed resource persons and panelists of this session, and above all, the vibrant young legal minds who are beating heart of this Junior National Law Conference, good morning. It is an honor and a profound privilege to be with you today as we gather under the banner of Raise the Bar. This theme is not merely a call to elevate our standards, it is a clarion challenge to redefine what excellence in the law truly means. Not just technical mastery, but a relentless pursuit of equity, integration, and justice for every citizen on this island we call home. The Supreme Court of Sri Lanka has spent decades interpreting the Constitution's promise of equity, that sacred Article 12, which declares no citizen shall be discriminated against on grounds of race, religion, sex, or any other status. Yet in the quiet corridors of our courts and the shadowed villages beyond Colombo skyline, we have witnessed how that promise often falters, not from any shortfall in the ink of our statutes, but for the deep gap of access that separates the privileged from the powerless. Today, in this session, as we delve into Pillar 3 of our conference, equal access to justice, building a legal voice for the voiceless, I'm here to remind us that justice is not luxury, estate, gated for the elite. It is the air we all breathe, the ground we all walk upon, and you, the junior members of the bar in this room, hold the key to flinging those gates wide open. Let me begin with an example, one engraved not in the archives of great judgments, but in the everyday tragedies that haunt our nation's conscience. Imagine a young mother in the tea estates of Nuerelia, her hands calloused from plucking leaves that fuel our economy, yet her voice silenced by eviction notices she cannot read. Or a person that engages in fishing as a livelihood in Jaffna, his nets empty not just from depleting seas, but from land disputes unresolved because the nearest lawyer is a day's journey away and the cost, a fortune that he does not possess. These are not footnotes in legal textbooks. They are the flesh and blood realities of inequality in Sri Lanka. Poverty is not just an economic ill. It constitutes a grave legal disorder, breeding a justice gap where the voiceless remain unheard and the vulnerable are preyed upon by systems meant to protect them. This, ladies and gentlemen, is a privilege we must confront, not the accident of our birth into families that could afford law college fees or private university fees, but the systemic advantage that enables some to sail through courtrooms with ease, while others suffocate under mountains of documents and endless delays. The legal profession bears a solemn responsibility here. As officers of the court, sworn to uphold rule of law, we are not mere advocates for clients who can pay retainers in the lakhs. We are not mere advocates for clients who can. We are stewards of public trust, bound by our oaths, ensure that justice flows like our island's rivers, abundant, impartial, and reaching every corner of our land. The Bar Association of Sri Lanka, from the heart of Hulsdorf to the outreach clinics in Batticaloa, have long championed legal aid, but it is not enough for a handful of us to dip our toes. It demands a tidal wave of commitment from all. And herein lies the transformative spark of this session's topic, justice beyond privilege, the legal profession's responsibility to ensure equal access and the transformative role of junior lawyers in bridging the justice gap. You, the junior members, fresh from the benches of Sri Lanka Law College, maybe, or the universities, are not peripheral supplementary players in this drama. You are its main characters. Why? Because at this early juncture in your professional paths, unburdened by the weight of invoiceable hours in chamber practice, you possess the agility, the idealism, and the hunger to innovate where customs have grown rigid. Pro bono legal work or legal aid is not detour from your path to lucrative practice. It's the essential element that shapes and strengthens your success in your legal career. Yes, let us not glamorize this role without being extremely thorough with our legal knowledge and courtcraft. To truly build a legal voice for the voiceless, you must immerse yourselves deeply into in the study and practice of the law, not superficially, but extensively, across its vast and intricate fields. The principles of equity, precedent, and procedure are not mere academic exercises. They are the armory you need to arm the marginalized against the polished and veteran counsel. I have presided over cases where earnest pro bono lawyers, hearts embossed with compassion, faltered not from lack of enthusiasm, but from gaps in their command of constitutional nonsense or procedural doctrines. A land rights dispute in a remote province, for instance, can hinge on profound interpretations of the Land Development Ordinance or the Prescription Ordinance, domains in which the opposing counsel has become experts through decades and complex as a spider's web. So if you are not fully conversant with such provisions of law and unaware of how to face the challenges of the opposing party, you fall in your duty towards your client. No amount of goodwill substitutes true skills. Your hard work could fall apart during intense cross-examination, leaving your clients more voiceless than before. Thus, as you commit hours to legal aid clinics, commit equally to accelerate learning the true essence of law by mastering the legal principles and familiarizing yourself with the evidence ordinance, civil procedure code, criminal procedure code, etc. Learn to dissect judgments from our apex court on human rights and administrative law, etc. Skill in every field, civil, criminal, commercial, or constitutional, equips you to encounter the veterans not with bluster, but with precision, turning the tide for those who cannot afford to lose. This dual discipline, pro bono work, and deep legal skills is the real magic that turns your quiet voice into a loud roar, ensuring that the voiceless do not merely speak, but are heard and heeded in halls of power. Consider the objectives we have set for this session to eliminate the inequalities that fracture our society and to ignite in you a fire to see legal aid not as charity but as a duty, a core thread in the fabric of your professional identity. I have seen it firsthand. Engaging in legal aid work is not just about bridging a gap, but building a bridge, one that carries his or her own career across to new horizons. Through pro bono work, one can sharpen skills in negotiation and evidence gathering under pressure far beyond the sterile stimulations of moot courts. Then you develop networks not in luxury chambers but in community halls, connecting with grassroots activists. This reminds us that law is not about winning cases but winning dignity for the defeated. I have said this at many lectures, but I need to repeat it today as well. Life is not qualified by fluent English, branded clothes, or rich lifestyle. It is measured by the number of faces who smile when they hear your name. This is the opportunity legal aid offers you, personal and career development. It sharpens your empathy into advocacy, your research into real-world impact. In a nation where women and minorities still face disproportionate hurdles, think of the single mothers in urban slums battling domestic violence without counsel, or the less privileged mother or father who suffers due to gross ingratitude due to conduct of their children, or an alleged criminal who had genuine thoughts. Your involvement isn't optional, it's revolutionary. These are the exposures that transform a competent lawyer into a compassionate one, a practitioner into a reformer, In closing, as we raise the bar at this Junior Law Conference 2025, let us resolve to step beyond privilege and engage in the battle. Volunteer not because it is easy, but because it is essential. Bridge the gap not for acclaim, but for the silent thanks reflected in a widow's eyes or the straightened shoulders of a child who sees the law as a protector, not an opponent. In closing, I leave you with the charge. Let your careers be measured not by the cases you win for the wealthy, but by voices you raise for the weak. Raise the bar, yes, raise it high enough for all to reach. Thank you, and may the balance of justice forever remain steady and true in your hands. Thank you very much.
Empathy and compassion. Thank you, Your Lordship, for those enlightening and encouraging address for the young participants who are seated today. It's a truly honorable occasion for all the participants here to benefit from Your Lordship's insights and experience. Before we enter into the second part of our session, let me introduce the two resource persons who are also contributing with their insights and experience. I would like to first introduce President's Counsel, Mr. Vivekanandan Puvidaran. Mr. Puvidaran entered the profession and enrolled in 1991, and he was granted his CILS in 2017. Mr. Puvidaran has professional experience for over 3 decades in the profession. Mr. Puvidaran has served as a State Counsel at the Honorable Attorney General's Department before joining the private bar. Mr. Puvidaran also holds a Master of Laws degree from the University of Colombo. A seasoned legal educator, Mr. Puvidaran was also a visiting lecturer and a long-serving examiner at the Sri Lanka Law College, focusing on the law of property and civil procedure. Mr. Puvidaran served as a commissioner in the Legal Aid Commission from the year 2023 and has been serving as the chairman of the Legal Aid Commission from May 2025 this year. Our next panelist is Mr. Harith Dimel, attorney at law. Mr. Dimel was called to the bar in the year 2013. His academic qualifications include an LLB from the University of London and a master's degree in law, international commercial law from the University of Sussex. He was honored with the prestigious Shepning Scholarship for the year 2023 and 24. Mr. Dimel is also a member of the Executive Committee of the Bar Association of Sri Lanka for the year 2024-25, and he is the Deputy Chairman of the BASL Commercial Law Committee and convener of the BASL Legal Aid Committee. Mr. Dimel is actively engaged in litigation with hands-on experience in taking upon matters from the Legal Aid Commission of Sri Lanka. Now I hand over this session to the two panelists, and President's Counsel, Mr. Puvidaran, if you may start the proceedings.
Thank you. His Lordship, Justice Sobhita Rajakarna, the Chair. Can't hear. Yes, and my dear colleagues, especially I must say Ruin Veer Singh, the Chairman of the National Law Conference Junior Bar. All of you, I'm thankful to, I'm in fact privileged to be here and have a session on behalf of the, in fact, I am on behalf of the Legal Aid Commission. I wish to make some comments, and also I wish to say something about the Legal Aid Commission. So I was given an opportunity by the chairman, who is one of our best panel lawyer, and he always come forward to assist us in difficult cases, in difficult times. So he is always there, and sometimes we always ask his help, advice also. He is very willingly, he comes and give us the full support to the Legal Aid Commission. So I thank you. And also, I think about 25 members of our Legal Aid panel lawyers have been given sponsorship to participate in this event. So the Legal Aid Commission is thankful to the entire committee of the Junior Bar. I think most of you all, not all, most of the members have come. So I am thankful to the Legal Aid, on behalf of the Legal Aid Commission, I thank the committee. Now, shall we? Yes. Now, if I take legal aid, you all might, some of you might think that it is a charity. No, it is not charity. It is a legal aid, is the right. They have a right to be represented in any court. So they are, for that, the state has to provide, because there can be, the underprivileged cannot be left out of the system, because we have a system where all must be in a system. We must try to include everybody. So it's an inclusiveness policy. Because of the inclusive theory, we have to bring everybody, because there was a, in one of our discussions, there was a discussion that it was brought to say that the criminal cases we should not accept. We accept, you know, the Legal Aid Commission. If I say a few words about Legal Aid Commission, we take up cases, the divorce, maintenance, bail matters, and fundamental rights, writ applications, and other cases such as, you know, sometimes there are the needy. So there are needy people, they come for land cases, even we accept cases. So there was an argument that whether we should accept criminal cases. So there was one point was put forward, because the funds are coming from the state, and that is from the taxpayers' money. So the criminals should not be protected. No. We said no, there was a big argument. We said no, it cannot be, because they have to be included, because it is, they became criminal maybe sometimes because of the society, because of the system that we have it here. A group of people can say that no, the system is wrong. So then who to find fault? So then we cannot say it is the taxpayers' money. It is the state which has to see every citizen is included in the system. It's an inclusiveness policy. So we have to bring every person, and we have to give him legal representation. In the meantime, we thought we will give them rehabilitation whenever necessary, and so then, and also counseling, consultations, and all that we are going to. So in the future, now we have accepted, we are going to accept criminal cases as well. All the criminal cases we are going to accept and do. Only thing is, there is a criteria, deserving person criteria is there. If anybody comes within that, we will be taking up cases. So now here today, the topic is why we should do this legal aid, the juniors, or even anybody, the lawyers. As His Lordship said, we are privileged to be here, and we were privileged to be lawyers. So this privilege was not there for a lot of other people, those who are burdened with their issues. So now that the legal aid, the legal profession is not a profession where we have working with papers and all that. It's a profession we have code of ethics. So the code of ethics is there. Because of the code of ethics, we have only doctors and lawyers, we have the bigger code of ethics where we are bound to, we are responsible for the society as well as the people and to the court. So here it is our duty to see that justice is given to all. Justice is for all. Justice for all. So that must be there. So I think we can take it from you also. Some of the
Thank you, sir.
Your experience in doing, I think Ms. Hardimel also is one of our panel. He has done cases for the Legal Aid Commission, so he also will contribute to the discussion. Yes, please.
Thank you, sir. So as Mr. Puidaran said, what I will speak to you about is a little bit of my experience in coming to the Legal Aid Commission far back as in 2013. So the first point as junior lawyers is that you must be willing to do legal aid, and your motives or intentions need not necessarily be selfless. In my case, in 2013, I went and registered as a panel lawyer with the Legal Aid Commission because I wanted briefs. I didn't have briefs. Nobody was there to give me briefs. I didn't come from a legal family. And I wanted to put my knowledge to the test. So I went and registered. So the first step of being a transformative lawyer as a junior lawyer is, as Ruane and several others from this have done, is to go and empanel yourself with the legal aid within your area. So once I did that, it's not necessarily that the briefs will start falling on your lap. Just because you want cases doesn't mean you will get cases. There are a lot of people, a lot of voiceless people who come to the Legal Aid Commission from all walks of life. And as Justice Rajakaruna said, privilege is not necessarily being rich. There are people who are rich who are also underprivileged. There are people who have different problems in the society who don't have access to justice for several reasons. They can be rich, they can be poor. They can be from Colombo, they can be from Jaffna. But by going to legal aid, what I realized was you can really become that voice. So my first case from the legal aid was not an easy case and did not easily come to me. Almost every day I used to go to the Legal Aid Commission and almost beg for cases in the first few months. And for you also, just because you empanel or register yourself doesn't mean that the Legal Aid Commission is looking after you, because at that point, they don't know of you. You have not been tested. So at the first point as a junior lawyer, keep going to the Legal Aid Commission. Talk to the officers there. Be there. See the people there. Maybe just participate in some meetings of even other lawyers there. And then I was maybe even bordering harassing the Legal Aid Commission at that time to get cases, and somehow I got a case. Then when you get that case, one important thing for all the junior lawyers to think about is, there's that moment where you realize this is the first time that the responsibility is on you. It's not your senior, it's not somebody else, but it's on you. And the client will tell you something, and you have to make the decisions. That is the most important maturing point of a legal aid lawyer or a lawyer, where the decision is on you. And that is a very, very important step for any lawyer to take that step. When you take that step, you may not be the best lawyer, you may not be knowing everything, but one thing Justice Janak De Silva said to you all yesterday was, in these first 5 years, get your fundamentals right. If your first principles are good, when you get the case, you should be able to get the case, study the law, and apply it. You may not be knowing the subject fully. So I'll tell you my personal experience, my first 2 cases. The first case was a malicious assault case of a man who was working in the Manning market. He was assaulted by a neighbor and he lost the use of his left hand. And he wanted to file action for injury or for damages. So the Legal Aid Commission told me that I can take the case and do it. I was very happy. But then I told, as my senior counsel has told me, I can't file proxy because I want to be a counsel. I said, I can't file proxy. The Legal Aid Commission told me, that's your responsibility. If you take the case, you got to do it. So then what I did was, I couldn't file a proxy. I didn't know how to file a proxy because I'm a counsel. I actually paid some money to another young lawyer to file a proxy for my client from my own funds. So he filed a proxy and I went into the case. And later on only he realized I am paying him to file a proxy for my legal aid case. Then my second case was where it was a money recovery defense, where we had to take it was a final date for answer, and about a week before the case came to me. And I had only done pleadings up to that time in English. I had never done pleadings in Sinhala at that time or properly. So I did the pleadings in English and I went to the Legal Aid Commission and said, I've done the pleadings. Can I get this translated? The Legal Aid Commission told me, that's your duty, you have to do it. So I put some money of my own and got it translated. But those are little challenges that you face in those first few years. When you take on a case, you must invest in it and take that responsibility and take the challenges. So after those first few cases, being recognized as a person who can do some work for the Legal Aid Commission, they started filing proxy and they started assisting with the drafts. Now, as Mr. Puvidaran said, what is it about the duty? You get a lot from it yourself. You earn a lot of development professionally as well as personally, and a lot of satisfaction appearing for the voiceless. Justice Rajakarna said also that it's about doing something for the voiceless. And that, with time, really does develop. And you get recognition from the bench, you get recognition from the bar, from your colleagues, and you get a lot of experience. Some call it betting experience. But as Justice Rajakarna also said, it's not about an experiment. It's not about going there and trying your best and doing something, right? Because access to justice also means not just being represented, but being represented with quality. So I'll pause there and come back to maybe Mr. Puvidaran to continue the discussion.
Yeah, I think at this juncture I should say that he said that he didn't have a brief. Yes, at the beginning we won't have any briefs. We will be just going to court and come back. So sometimes you don't know why should I go to court. So one thing is, you must understand, in this profession, you must be seen. That is your availability. You must be, if you want to do court work, you must be seen in court. You must be available in court. People must know that so-and-so is there as a lawyer who is there, so only then they will give you work. As yesterday Justice Janakli Silva said, you must accept all the cases, whatever comes in your way. But only thing is how to. When they don't know, when the people doesn't know that you are there. Sometimes at the beginning people won't know that whether you exist or not even, as a lawyer. So for that, you must be seen in court. You must be available every day in court. For you to be available in court, you can also just go without a brief. So in fact, I also in the year 1992, I took up myself and Mr. Mohammed Maki, who was a retired High Court judge. He's in now Fiji. We both of us, you go to the Legal Aid Commission. That time, we didn't have any problem, as Harit said. We were given cases of the detainees that time. So we used to take the file and draft and give the plaints. Then they will file it in the Supreme Court FR matters. Then we go and appear. So then you have every day you have a case to go before the court. So the people come to know. So your availability, you are getting connections, connections, and you have contacts, you get contacts with the lawyers. And most probably sometimes you will be pitted against a very senior lawyer, sometimes the President's Counsel, a very senior lawyer in the profession on the other side. But you won't get a brief you can't charge. Sometimes if you are doing it on your own, sometimes the people won't come. On the other side, if it's a senior lawyer, they will definitely look for a senior lawyer. But in a case of legal aid, and also when we were in the Attorney General's department also, we had that opportunity. Maybe we were very juniors, but at that time, the senior President's Counsel, very senior lawyers will come and oppose against us. So we had that opportunity. In fact, the same thing happens in the Legal Aid Commission also. When you get a work, you will have work there. You can go and you don't require to go and be shy of yourself, thinking that I don't have a brief. Now what to do? The people might think, what is this? He is coming without a brief. No, you will have a brief if we accept pro bono work from the legal aid, and we have panel lawyers listing every district. We have our centers. They are the people, those who like to do pro bono. In fact, we pay a very, I should say, a small sum, but that may not be sufficient for you all. But any event, we are paying something. But that is not for that payment you are working. One is for your contacts, that you are going to have a brief, you are going to be seen, you are going to be available there in court. All that is going to be benefited for you. And also you are going to get drafts. The lawyers, you will not get a case. If you don't get a case, you can't get pleadings drafted, you can't get your laws. Sometimes, you would have studied for your exams. But after exams, you don't go and study the case laws and just for the sake of studying. But for a purpose, we will study. Generally, that is what happens. We don't go and just study there, and only a very few studious students will go and study without any purpose. But here, if you get a case, you will definitely, it will force you to go and study. You will have to study, you will have to discuss with your friends. So you will have some cases. So then that promotes you, and by that you can develop your advocacy, drafting, courtroom experience, everything you will receive. So this pro bono or the legal aid work will definitely benefit you at the beginning of your career. So it is always, I think, as Harit also said, it has, in fact, I also had the same experience. We were there, both of us used to go there and appear before the Supreme Court. That time, Justice Mark Fernando, Justice Amar Singh, they were sitting on the bench, and sometimes they are very, not like nowadays, they were sometimes very strict also, but they were courteous to the lawyers, and they sometimes, even if we make mistakes, they say no. Sometimes the matter might be settled, but sometimes the judges will say, no, here there is an assault. It's a fundamental rights application. You can't accept it, you can't withdraw this case, we will take over the further. So get the medical legal report done, and all those things they will do. So then we learn from there. What is fundamental rights, why, and how can the court take over that? Though the party wanted to withdraw, no, it is the right of the citizen. Declaration is a right. So it is, the court can declare it. So all those things we learn from that. So it is a learning ground. It gives you a good learning. So we should, I think it will be for your personal benefit as well. Also, for that also, the legal aid work, whether you are doing with the Legal Aid Commission or even out of that. Because justice for all. People, because this system is there to give some solution to every problem. People will have problems, disputes, but every problem must have a solution. no problem can go without a solution. So for that, now here, even you can take up cases on your own for free of charge, you can do it. But with the Legal Aid Commission, we also there. It is a state funded as well as we are funded by the UNDP also assist us. Earlier USAID, now Norwegian Refugee Council. So likewise, so there are other institutions that also assist the Legal Aid Commission in doing the work here. So we are there about 86 centers are there, and we are going to start 2 more centers within this year. So there are about 135 legal officers working for the Legal Aid Commission, and we have panel lawyers who are registered there. So then they will get cases, and we will be giving them cases to appear and drafting everything. Even if counsel, if you want to do counseling, we can give the instructing part, we can take over. Need not be like Harit had that difficulty there those days. Now we have, what we do is, sometimes if the person want to do, I think with Ruin's matter also, we do the instructing work. Our legal officers will do the instructing part of it, and they have to do only the counsel work. So those who want to do counsel work also, they can do the counsel work. Only thing is, we will do the instructing work, with the Legal Aid Commission will take over that and can continue.
Thank you very much, sir. Now I would like to pose a question to His Lordship, Sohita Rajakaruna, sir. Now, sir, you emphasized on the fact that a lawyer, especially a young lawyer, should be empathetic and compassionate towards his clients. But however, personally, as human beings, we would have much of a bias towards people who actually pay us rather than the people who, after some time, we might think that this is intolerable or this is not a case where I'm getting paid. So why should I bother? Or why should I think about this too much? Why should I give this client too much of my time? And also, sir, how, when you were in the Attorney General's department, and how you also view this aspect from the bench?
Thank you. Thank you. Actually, the compassionate or the empathy can come out in various ways. First of all, I have to highlight here that our whole exercise in this conference is not to market pro bono cases or market the Legal Aid Commission. I would redefine that in this way. When I was talking, study your brief. You have to study your case. You have to study all the fields of law. Whatever you get, even a very basic agrarian research case, do it at your level best. So when you work hard, when you study, there should be a place to market your work. At that point, in my redefining way, I would say, that's a marketing of your work, pro bono cases. So you can get that opportunity, you can grab it. Now, last evening, His Lordship Justice Janak de Silva was talking about H.V. Perera. If you go through old NLRs, number of cases where H.V. Perera is a counsel, one of the giants in the bar, right? So first year or second year, first 2 years, I think, he said there were no cases, but he was engaging in pro bono cases. So what is the duty of a lawyer? In fact, Dinali is here from my chambers, and she has listened enough for my preaching. Sorry, I have to repeat. What is the duty of a lawyer? What is the duty of a lawyer? to protect the rights of a citizen. So how can you protect the right of a murderer? Your client is a murderer. He has killed somebody. How to protect the rights of that man? But that is where you have to use your wisdom. That is where you have to fight for the right of that criminal. There must be some sort of a right. There must be some failing in some point, failing in evidence. You should be able to grab that. There should be some fault of the state counsel leading in evidence. Try to grab it. You have to be wise enough to look for that false. Can be technical fault, but doesn't matter. How he was arrested, how he was taken in custody, how the police reacted. So there may be some sort of a right. So that is the duty of a lawyer. That you have to apply. And always don't think that, I think I was very careful crafting my speech not to call junior lawyers. There are no junior lawyers. There are only junior members of the bar. The brain given to us equal. It's the way how you use it only. You become experienced or inexperienced. There's no junior senior thing. Maybe who is senior to me, that's the time that he is senior in law college. So that seniority is there. You have to respect the seniors. That is there. But always think you are equal to a higher level counsel. It's a way you use your brain with empathy, compassion, and good heart. And also, when, sorry, 1 minute, Mr. Puvidaran was telling that availability. I remember I was attending Mr. Rambanda Senivaratna's apprenticing classes. You always say, lawyer should not be always able, but he should always be available. You should walk around the corridors of Halsdorf, hang around in the canteen. One day, somebody come and ask you to take over your case. It happened to me. From day one, I was working at the Attorney General's department. But one day after cross-examining a witness, DC 6, I was coming out. Somebody who was there in the courtroom came out and asked me, "Sir, mage nadu bara ganna puluwanda?" Unfortunately, I was a state counsel with junior state counsel at that time, so I explained her and asked her to contact somebody else. So you will get that day at whatever point of time in your life. So I think that's enough for the answer for the question asked by.
So Krishan, with your permission, yes, you go ahead, sir. Just to comment, one thing I always also thought about, sir, was the perception that the public and the peers of the bar have about somebody doing legal aid. Some people tend to think that you're briefless. It's because you're briefless that you're going to do legal aid. Some people tend to think that it's because you want to get the honorarium Mr. Puvidaran mentioned, that you want to earn that 3,000 or 2,500 rupees by doing legal aid. There are perceptions that people feel, but in my view, the legal aid is a badge of honor. Personally, I am proud to carry a legal aid file with the legal aid logo and to say that I appear on the instructions of the Legal Aid Commission. And that is that sense of pride that you must have. Having said that, I think we must also appreciate what Mr. Puvidaran said about the work that the officers of the Legal Aid Commission do. If you go to the Legal Aid Commission, it's a very, very difficult job because none of those clients are paying clients for those lawyers who are employed there. Every day they come with problems, and the first thing they come is without documents. They have so much to say. They have to deal with the clients. If you're in the private bar, we say come with the documents. We'll give you a time when we'll charge you a fee. But we must all as junior lawyers appreciate the hard work that is done at the first stage of legal aid by the Legal Aid Commission and appreciate the hard work that they do. Because sometimes it's easy to criticize the Legal Aid Commission. People do criticize. There are sometimes good criticisms also. But it's a very difficult job. And that's why you come in as junior lawyers to assist them and to enable the work that they can do, so that Mr. Puidaran also mentioned about instructing attorneys. I also think, sir, that it's a very good idea to have more instructing attorneys empaneling themselves with the legal aid so that they can network with counsel. There are counsels who register who are generally the ones who get the work. But if there are no instructing attorneys from the outside empaneling, sometimes the counsel and the instructing attorneys from the private bar can do legal aid work. Because the legal aid work, I know, they have a lot of pressure because of so much work. They have to do all the instructing work. And the clients come to them, they cry to them, they call them, then they call us and we put pressure on them. So it's good if you are also an instructing attorney to empanel with the legal aid. And you can work with counsel, and that's not a bad way to do it. So you had something to comment, sir.
I'm sorry that, although they are not canvassing, but I'm duty bound to canvass for the Legal Aid Commission, and I am going to canvass and advertise legal aid because being the chairperson there, I have to do that. I'm sorry that, but it's not that canvassing, but it is that what it has to be now, that it's not only that to attract you all to the legal aid, but it is, I must say, there are about 20 odd panel lawyers are here. We have, and since the session is also on the legal aid, I have to also say the work that is done by the legal aid lawyers as well as the panel lawyers, that I must appreciate that, because this is one of the work, this is very important, because appreciating the work that is done. So in appreciation, I think now that we have decided to give the appreciation, the letter of appreciation to our panel lawyers if they have done number of cases in a year, 5 or 6 cases in a year. We are going to give them a letter of appreciation which can be used for their future. Sometimes if it is a judicial service commission, judicial interview, for the judge's interview, or any other work done, or even for some visa purposes, even if they have done a case, even if they are doing work. So we will be giving them letter, or sometimes if they have done the number of cases, we are going to appreciate them by giving the letter of appreciations by the Legal Aid Commission. In the addition, also I must say that, as His Lordship said, juniors, I always say yes. I also say you all are more intelligent than us. You all are knowledgeable than us, because it is not like we say that those days what we studied. No, it is not that, but we studied those days is lesser than that you all studied, or you all are studying at law college now, or in the schools even now. But we studied at in grade 12. You all are studying, you all would have studied in grade 9 or 7 or 8. Because now that the knowledge of the world, the entire world, is doubling in 10 years, not in 100 years like those days. So then always you all are more intelligent. Only thing is we have some experience in that field. But you all are more intelligent to handle the situation, present situation. We all are in a learning process. We all have to, in our generation, I always think that we must learn, continue to learn, to match with you all. The technicality, and during our days, we'll have to go and look for anything, we have to go and search the library. Nowadays, the entire knowledge is, or entire information is around you here. You just want to have the phone, you download it, you are having it. We didn't have that opportunity. If somebody says here today, we will have to go to the library and refer the matter, get a photocopy, take it, and we have to take note, we have to write it. But it is here for you all. So it is, in fact, you all are progressing. So when the progressing is there, always the younger generation is more intelligent than the earlier generation. That is how we were also. We were, in fact, intelligent than, our generation was intelligent than the previous one, and the one. Otherwise, we will be going behind in the history, in the progress. So we are proceeding, going progress. So the progressness is there. So then you all must be confident that you all are more equipped, more you can, if you like, if you want, you can gather more knowledge, you can get more knowledge, because knowledge is studying, knowledge is never ending. You can gather every day, you will have to, it's not ending. So you all are the younger generation, you will have to take this further. So this legal aid also, as I said, is one of the society, and also to maintain the system. The system that we have, I would say it is not a, we are not doing revolution here. If it is a revolution, you can understand it's, you sometimes, some of the revolutions have eliminated the sect of people or group of people out of the entire society. But here it is not that. We are not trying to do that. We are not doing that. We are trying to include, as I said earlier, it's an inclusiveness. We are trying to get everybody into the system. We are trying to update them. We are trying to bring their standard. Similarly, the justice also must be given to everybody. So justice for all is one of the theme that now the Ministry of Justice and the UNDP with the JSC, everybody is working on it.
Thank you, sir. Thank you very much for that. I would like to open the, with the permission of the panel, I would like to open the floor for any questions that the junior members of the law, the bar might have. We won't have much time for questions since we are running a bit late, bit behind schedule.
Sir, now I'm aware that the primary focus is litigation. However, sir, no, the law does not exist in a vacuum, and there are a lot of social and economic factors also. And sir, you yourself mentioned in your speech about the concept of rehabilitation. Sir, could you perhaps expand further and give your thoughts on this?
Yeah. Now the rehabilitation is, you know, there is a rehabilitation, you can see it. Rehabilitation, there is a rehabilitation department of ministries there. There is a separate under the Ministry of Justice. But now what we are trying to do is with the legal aid and the rehabilitation, when there are drug addicts, because they also have to be absorbed into the society. We can't just leave them and go. They may be one of our neighbor, all that. So then we are trying to, what we are trying to do is, if we are accepting those cases, we have to send them for rehabilitation. How to get a mechanism for that through the legal aid. When a case comes to legal aid of such nature, how to channel them to the rehabilitation. So that mechanism we are trying to work out. So similarly for counseling also, like the divorce and the maintenance cases, divorce cases and all that, we can send them to counseling for them to be patch it up, and they can get on together and they can settle the matter without coming to court. So that is also we are trying to have a mechanism. So that is in the process of trying to find a mechanism with the working mechanism with the rehabilitation ministry and the counseling with the doctors and all that.
Thank you very much, sir. And we have run out of time. So as a last question, I would like to ask from Mr. Dimmer. Now, how did you tackle important social issues which were brought up with the Legal Aid Commission, such as matters which are public interest litigation matters? How were you able to tackle these matters? Any experience that you want to share with the junior members of the bar?
Thanks, Krishan. So on that, it's not just the cases of individuals, but and the transformative role of a junior lawyer, what you can realize is you can change the life of a person And also you can use your role as a lawyer to change the lives of others through the cases that you do by setting precedent. So for example, in 2016, the Legal Aid case commission had a case where a child who was under 18 could not be adopted because the adoption law said a child is a person who is not under the age of 15. The law had not been amended. So the Legal Aid Commission went and I appeared and we argued before the court that the interpretation must be 18 and not 15 under the purposive interpretation. And that was one instance where that law, the judgment was given and I think it was spread across the centers that could use that as an argument. And another very good example was where a lady who had HIV had a cause of action against a media firm. And she wanted to sue. So the problem was she didn't want her name to be associated with her condition. That was her cause of action. So she came to the Legal Aid Commission. Mrs. Ahabandu was the chairman then. And that was the first time that we did the case. The Legal Aid Commission went to court as the petitioner for special directions as to how a person who is marginalized can come to court without disclosing her identity. It is reported in 2020 Bar Association Law Reports 286. The petitioner is the Legal Aid Commission. And we got orders from the court how such a person can come to court, maintain her anonymity, and how the court process can be done, which was a special case where the Legal Aid Commission was the petitioner. So my invitation to the junior lawyers is to use your ability, your skills, and your passion for the law and to develop the law. Public interest litigation can be done in the name of the Legal Aid Commission. And there are so many problems the public face. A classic problem these days, sir, is the insurance companies. When there are judgments given for the plaintiffs of the Legal Aid Commission, they appeal to the Civil Appeal High Court and to the Supreme Court. Currently, we are doing a case. We are arguing that an insurance company does not suffer irreparable harm from the writ being executed pending appeal because it is their business. So we invite you to be part of that transformative role. Apart from appearing for clients, use the Legal Aid Commission and that forum to be a voice by public interest litigation and even changing the way the law works. Hopefully, 2020 BLR 286 will now become an amendment to the Civil Procedure Code. But that is, Krishan, what I think social causes you can bring to the Legal Aid Commission. And as Puidaran sir said, legal aid is not limited to Legal Aid Commission. There are so many other organizations, UNDP, I think the iPro Bono, which is going to speak to you later, so many organizations. So you can bring them, specialized agencies, to the Legal Aid Commission and ensure that you have a role beyond just one case or two cases, impact generations. And we as young practitioners who have worked with the Legal Aid Commission are always there to help you with any advice, any mentorship. If you want a draft, advice, any problem, you can always call. And that also goes to the Legal Aid Commission officers as well.
Thank you, Harit, for that insightful information. So this goes out to the members in the audience as well. Like, if you have any social cause or any matter you think is deserving to be taken up before the Legal Aid Commission, the Commission is always open for such matters, and they will always assist your clients and yourself in litigating those matters. The Commission might take up the matter if it falls under the criteria, but however, that option is always available if there is a pressing social issue or if there is a deserving client which you on principle won't be able to take up, but surely you will be able to refer that matter to the Legal Aid Commission, where they will be able to sort the issue out for the client and move the matter forward. With that being said, unfortunately, due to the lack of time, we have to conclude our session. And I would like to thank the panelists, His Lordship Justice Sohita Rajakaruna, President's Counsel Mr. Puidaran, and Mr. Harit Dimel, Attorney at Law. I would like to thank you all for sharing your insightful information and also sharing with us the knowledge and the expertise that you have which might guide the young members of the bar in pursuing their careers and also in pursuing any matter which comes before them, to study it fully and thoroughly and also bring justice to their clients. Thank you all. And I would like to invite Mr. Tisha Veragoda, Chairman Junior Bar, and also Mr. Gamilu Karunasena, Sessions Head, to award the panelists with a small token of appreciation. Once again, I would like to thank the panelists for sharing their insightful information. Now with that, we can move on to the second session, which is going to be a practical workshop, which is conducted by iPro Bono. And Mr. Aritha Vikramanayaka, who is the Equality Director at iPro Bono. A small introduction into Mr. Vikramasinghe is Mr. Vikramasinghe is the Equality Director at iPro Bono, General Counsel at Investment Bank TWC, and he is an advisor to the Governor of the Western Province. He was a former head of legal at the Sri Lankan Ministry of Finance's National Agency for Public-Private Partnerships. And also, he was a part of the advisory committee which advised the Sri Lankan government on financial, economic and social policy reform in various capacities. In the year 2023, he was nominated by the World Bank as a presidential advisor to support the President's office on the ongoing IMF and multicultural supported economic and social reform programming, which was conducted in Sri Lanka. Mr. Aritha continues to be a strong advocate for legal reform to strengthen the rights of women, children, and the LGBT community and other marginalized communities. With that, I would like to invite Mr. Aritha Vikramasinghe from iPro Bono to conduct their session on the theme Access to Justice in Action. Over to you, Mr. Vikramasinghe.
Hi, good morning. I had a bit of a name change from Vikramanayaka to Vikramasinghe. I get that all the time, actually, because we both have the same names, and sometimes his clients email me, and my clients email him. And most of the time, we know each other's clients, so we actually think it is for us that we're being written to. But anyways, just a brief one. I want to do a quick intro on iPro Bono and what we do and how we started, actually. We had a really amazing discussion before on the importance of pro bono work. And as my introducer emphasized, I'm not really a human rights lawyer. I'm actually a finance lawyer. And we started iPro Bono back in 2008 when I was in the UK. So we're actually a UK-based, but global organization. So back in 2008, some of you may remember, there was a global financial crisis. And in the UK, because of the global financial crisis, the government started cutting spending. And one of the first things they decided to cut spending on was legal aid. And when legal aid was being cut, what does that mean? That means that people who cannot afford to seek justice no longer got the support from the state to do so. That created a huge vacuum. And then lawyers like me, I was a trainee lawyer, just starting my legal career in London in a big corporate finance law firm. And we were talking to ourselves and we thought, okay, what can we as lawyers do now to step in? Because the reality of our lives as lawyers in these big, glamorous law firms was, most of the time I was reading and drafting 100, 300-page loan agreements. That was my job. It still is for a lot of it. But, I mean, you can raise your hands up. How many of you decided to become a lawyer because you wanted to draft a 300-page loan agreement? Anyone? No one? Yeah, exactly. Most of us decided to become lawyers because we believed in justice. But the reality of law is that justice often doesn't pay. So you got to make ends meet, and you pursue other passions of law, which also have purpose. So we thought, okay, how do we as lawyers now step in? How do we bridge this access to justice? How do we bring together these lawyers who are working in corporate law firms, in other different types of law, to step in and provide pro bono legal work for people who no longer could access legal aid? And that was the founding for iPro Bono. It was sort of like a Tinder for people who needed lawyers and to match them with, basically, it was like a Tinder to match people who needed lawyers with lawyers who were willing to do it for free. And that was before Tinder. Of course, iPro Bono has evolved a lot since then. Today we are a global network of 80,000 lawyers in 40+ countries. And every day, our lawyers are delivering millions of dollars worth of free legal assistance to people who really need it. And in Sri Lanka, we've been operating for almost 10 years now, where we're working with an incredible cohort of lawyers. We've sort of changed our model. We're not sort of like a Tinder-based model anymore. We really focus on investing in our lawyers. So we have programs where we train pro bono lawyers on the different types of cases that can come up to them. So we've built a specialism for especially issues that affect women, issues that affect children, issues that affect the LGBT+ community, and labor issues. So we do workshops where we train lawyers on the law, the procedure, how to step in. We've created a fund because we know that actually pro bono work doesn't pay. And especially for juniors, it's not necessarily fair that we expect them to step in and do a lot of free work. So we've created a low bono fund where we are able to disperse payments to junior lawyers to conduct that work. So that is a brief start into iPro Bono. I want to introduce two brilliant lawyers who work with us day in and day out, Jerusha and Shevendri. Please, if you can come forward. And we're going to do a little case study with all of you. But before we move into the case study, I think one of the things we asked was, I asked was, why did you want to become a lawyer? So we're going to move around this table. Maybe I'll ask you, why did you choose to become a lawyer?
I'm from government sector, and I decided to serve the government as a lawyer.
Great. Jerusha, why did you want to become a lawyer?
So I saw a lot of violence against women when I was growing up, and I always wanted to be a voice for women and children in particular. And just to add to what he said, when I wanted to do that area of law, and I started 15 years ago, everyone was like, you're going to be poor. That's rights doesn't pay, do something else. But as we've come a long way now, it's become more of a buzz topic, helping people and setting the bar straight, or raising the bar, as you all have been talking about, has become more popular. And so now we have a lot of support with that kind of case, but that's why, to serve groups of people who don't have a voice generally.
Hello. So I was always fascinated with the legal profession, and I knew that I wanted to get into criminal law. But it was after I took oaths and I started practicing that I actually found my purpose and what I was passionate about. I think when you actually get into the work, you see the realities of the system and how the system is stacked against the marginalized communities and vulnerable groups. And as lawyers, I think we are uniquely positioned in a space or in a place where we can actually advocate for those who can't advocate for themselves. And that's what inspired me to get into this work.
How about you?
This was my plan B, so.
What was plan A?
Join the military, and my parents, they didn't give me permission.
All right. It's a good plan B, though. Okay, so we would have, if you look at your phones, and there's a WhatsApp group which all of you are a member of, we have shared a case study for all of you. So we are going to make this part of the workshop a bit more interactive. And we're going to divide this hall into different groups who will look at the case study. So there are 6 case studies. I'll let Shavindri and Jerusha explain them, and we'll divide up.
Okay, so we're going to get right into it. I think we have to make it as interactive as possible. So we're hoping that everyone is going to participate and share their insights and get involved. So there are 2 parts in each case study. One, we want one team to be the client support group, and then one for the courtroom strategy group. So each case study, there are 2 particular questions. Do you all have access to them? Yeah? So if you look at the case study at the bottom, there are 2 questions. So in terms of groups, I'm going to start from here. So you would be dealing with case study 1. Yeah?
This whole row?
Yeah, so this whole row will be with case study 1, and then you all have to answer. You can pick which question you want to answer, but make sure both
Work
questions
in
are
your tables.
answered. So this would be for case study 2, then 3 for these 3 tables. So this is 2, 3, 4, and then the last one 5, and then those at the back, you will be doing case study 6.
Everyone behind this panel.
Yeah, so the 3 tables at the back, you would be doing
work
case
in
study
groups.
6. Yeah, does that work?
Before you guys go into the case studies, can I just give you a little heads up on what to look at when you are looking at a pro bono case specifically? I just divided it into 3. I see a lot of my students also here. So one of the first things I talk about before lectures, we start lectures, is why you became a lawyer. And aside from clout and money, it's to serve. And sometimes equity is not okay if everybody gets the same amount of clout, because like they said, it's not in a vacuum. Some people have economic issues, some people have other issues, and everybody having the same kind of help doesn't help. These cases that are done pro bono specifically have a lot of survivors of trauma. So one thing to keep in mind is how you can assist a person who's going through some kind of trauma. In my chamber, I've had people who've had panic attacks, things like that. So it's important to note that either you need someone merited in psychosocial support with you, or that you can at least send your clients for that support, because otherwise it becomes difficult for you to handle that matter. So handling somebody like that, you have to go a little extra mile, which lawyers are not used to, because we're used to sitting on a pedestal and sort of telling people what to do. But when it's trauma-centric, you need to do a little more, be very sensitive to that kind of thing. And obviously, even if it's low bono or pro bono, give the same kind of attention to detail that you will a big client, because that's the kind of integrity that's expected as an attorney when you took oaths. And I would also say that it's important for all of us to incorporate some amount of pro bono or low bono work, because then we assist the community. You all saw recently when that lawyers versus cops thing happened, we took a lot of slack on social media. And that's not because we're an awful group of people. That's just because we have a lot of clout. I don't think many of us have got a parking ticket or a traffic ticket. And that's not because we're cool or special, but it's because they believe, like doctors, we are going to do something important. And we have that level of clout. But if you have that level of clout, that is because they expect you to give back also. They expect you to leave the community and people better than how you found them. So one thing to really focus on is how you would assist somebody who has a layer of trauma to what they're bringing to the table. Number 2 is case strategy. Always be creative with the laws. If you're helping survivors, Victim and Witness Protection Act is a must. I don't see a lot of lawyers use that, and that's something the younger ones can definitely start using, because there's a commission, there's a safe house, there's a lot of support for that kind of thing. How to use other laws, the HRC, there is hotlines for people's protection for NCPA, the Women's Commission has, the Women's Ministry has a hotline. Those other creative methods also you can look at when you're looking at these cases. And number 3 is how you will make sure that this particular case is taken to the highest form. So I just want to leave with you 2 examples. If we are talking about equity, then it has to apply to all. In our profession sometimes, if you are a famous lawyer's spouse or family, a lot of lawyers don't want to appear because we have a conflict of interest or a sort of loyalty to the person in the at the bar. But then that is actually a very big lack of justice to the other party. So are we the kind of people who will go out of our way to bridge that and stand up for anybody who needs that right? That is one thing to think about. And if it's our own people also, I don't know, but my senior, Mr. Sumandran, we at our chamber, it was, if you are appearing for a lawyer, generally you don't charge, because that person is. So I want to talk about a case where I had a student who's a lawyer and also a famous influencer, and she had a cyber violence case. And it's sensitive because it's somebody in the public eye. And my team handled it, and generally we don't charge. So she's not a pro bono client per se. It's not that she can't afford, but it's the decorum you give to another lawyer. But even if you're handling a matter like that, it has to still have all the specifics of what you'd give a normal case. So just remember strategy, trauma-informed, and how best you can take it along, whoever the party might be. Sometimes it might make you unpopular. Sometimes it might be a powerful person's opposing party, but your job is to make sure everybody has that access to justice. So just think about these 3 things when you all are looking at your cases. And you frame the cases for them.
If I can just add something to what Judicial already said. When we are practicing or in our work, I think we become really desensitized to cases, because for us it's just a file, it's just a job. But for a person that's actually going through it, it's a life-altering situation. And I think it's really important that we tread lightly and tread carefully and understand that they're going through something life-changing. So we have the opportunity to change someone's life, so we need to do what we can to support, especially vulnerable clients. We've done so many cases where clients have actually been contemplating suicide, or they've been going through really, really bad trauma. So we must be cautious in how we approach. It's beyond our professional duty, but it's important that you actually be a friend to your client, because they're going through something, and we would obviously listen to our friends' problems, and sometimes it can be a daunting process, but we have to be friends to our clients. So I just wanted to add that. Also, I think as pro bono lawyers, it has been a really rewarding experience for me. It has helped with my professional development, and also it has been it has given me a purpose. So I urge you all to get into the pro bono practice or incorporate some pro bono work in your career. Thank you.
And actually, to touch on sort of trauma-centered lawyering, you really touched on it, both Jerusha and Shavindri. A lot of the times we are our clients as therapists, and we try so much to refer the clients to professional therapists, and a lot of the time they refuse to, because they build such a sense of trust and safety with you as a lawyer that they're unable to trust another person with the sensitive issue that they've gone through. So it can be quite emotionally taxing even for us as lawyers, and sometimes we go for therapy ourselves to deal with some of the issues that we have to deal with. But it is still very rewarding, and I think it's made all of us so much better as lawyers, and it's made me a better banking lawyer just through the pro bono work I do. So look at your cases now. We're going to give you about 20 minutes to look through them in your tables, discuss your strategies and your solutions, and then we'll ask you some questions after. Thanks.
Hope everyone's doing okay with the case studies. Just to let you all know, these are all real cases that we have worked on at iPro Bono. Also, just to let you know that from each group or each table, nominate one speaker per table who's going to represent the group. I'm just urging you all to discuss and come up with your strategies together. The third one, right? So that's the domestic work, the brothels. Okay. So think about the situation. So how can we make sure that So we have about 5 minutes more, just letting you know. We can start presenting in about 5 minutes.
wonderful session.
Yeah.
Yes, yes. He is the moderator. Yeah. I'll see you now. I'm talking procedure of all things.
Yes, yes.
You can't do without it. Absolutely. Yeah, true enough. I walked in at the last part of your initial talk where you were talking about agreements. Absolutely. I liked your comment about therapy. We do it too. We have a therapist. And I find it was helpful the way I approached it. Sorry, I didn't introduce myself in person.
Anil. Anil Madhu.
From this way. Yeah. You're one of the therapists. Gosh, I'm so sorry. How could I do this? So, but gosh, I'm so sorry. Alright, who is your point of contact? Our managing partner is Savanthari. Yeah. You must be talking to FJs.
Yeah.
Alright, I'll tell you my matching.
Questions about the first case?
Warm, non-judgmental and safe environment for Mohan so that he can share his story without re-traumatization or fear of it.
What do you think about it? What do you think that the issue is to his sexuality?
Yeah, since he's not protected by the law.
Actually, he is protected by the law.
I mean, because he's worried about telling it out because he feels that he'll get released.
So there are a few things which can work in his favor. So homosexuality is not criminalized. Certain sexual acts which are criminalized. So there's a police circular which was issued a few years ago, which prohibits police officers from discriminating against LGBT community. And in the Victims of Crime, Protection of Victims of Crimes Act, it specifically creates an obligation that to be sensitive for vulnerable groups, and it mentions people of diverse sexual orientation and gender identity. So the law recognizes the sensitivity of the nature and the fact that you have to be sensitive and respectful of it. So those are things in the law which we can use to protect him and ensure that the police treats him with the level of respect and discretion. Model that you have created for pro bono, is it in Sri Lanka? Yeah, we have a presence here. We have about 200 lawyers almost.
Advocating is legal aid can't handle. You need the private sector participation because here we don't have any private sector legal aid in that way, not formalized.
Yeah.
So that's really good because I'm now appointed as national consultant for UNDP for a national legal aid plan.
Okay.
So I'll be starting next week. I would love to bring any providers into the framework because otherwise you go as formal legal aid and informal legal aid. We need to just say that everybody is legal aid.
Exactly.
Because they really can't handle the workload.
Yeah, that's why we're trying to get same in the UK. I mean, the government can't handle all the workload, so private lawyers have to step in. And what I want to do is we structure the lawyers also contribute
Because we all make money from this.
Yeah.
See, it's not so many people can contribute. There are some people who will do pro bono work, but there will be enough and more people who will need to park with a few thousand rupees on a monthly basis or something. The legal aid fund is also a problem because it's regulated by the government.
Okay.
For example, if you take North and East, when it comes to anything with regard to terrorism, they will say, no, we can't appear because we will be perceived as appearing in state, which is totally wrong.
Most of the money in the UK and many countries for legal aid goes for defense work. Criminal defense work is actually the bulk of the money.
Maybe he said that, but for a long time they have been of that view. So it's good. So you have an office here, is it?
We have, I mean, we have a very small office, only like 3, 4 of us.
I see.
Because
I know
our model,
because she's around. My seniority, we have worked together, oppose each other, and so we know. So I can connect through her.
Yeah, please do. And we're just preparing a proposal. We're meeting with Rajiv, DSL president.
Great.
Because he wants to have us to send a proposal so we can do something.
So I'm in the
together.
expo. So whatever that comes through it, I will know about it. And particularly that case I spoke about, it's a first time that we need this.
Yeah,
It's a John Doe, essentially a John Doe. So otherwise there is no John Doe in Sri Lanka.
Were you there for when there was a talk recently when the Indian Supreme Court Justice spoke?
Suryakant, yeah.
So he spoke on how their legal aid commission also fired.
How activists they are.
Yeah.
The difference is it's Supreme Court led. Now in Sri Lanka, the legal aid commission is largely commissioner led. The bar has a overall supervisory role, but we are very passive. We let the commission do whatever they want. The Supreme Court role comes in only through what is called a legal aid advisory commission, which is a defunct body. Only this year under Rajiv we started to try to get it going again. But when it comes to the bench itself, it just pushes through. Because then they are the ones who decide also. But that's why now so many important things to just get sidelined because of that lack of initiative.
Can we not propose amendments to the law where it creates a stronger nexus?
I
See
heard
how
you.
we can replicate the Indian model.
And legally is not necessarily only about what we do in court. It's about the advocacy, about speaking of issues.
A ton of our work is on advocacy, trying to shape policy, do round tables, like we're trying to work on case backlog. So we get a round table, child rights organization, human rights commission, coming up with how to administratively solve. And also a lot of
That's great. So we can certainly connect.
Yeah, let's do something. I'll get your number.
I don't have a card, but
I'll just add
you
you on
can just exchange numbers. Yeah.
WhatsApp.
Shall we start? Yeah, when you're done.
Yes.
WhatsApp is a UK number.
Okay. Yeah. No, we'll keep in touch. Because of this national legal aid plan, I'm trying to bring all the other actors.
Yeah. So you're doing that. Going to do that with
UNDP. Yeah. There's the international consultants, so they have a really good plan. And much of the problems are really because of the lack of
Okay, so
plans.
hello. Hi, is everyone ready to start the discussion? Hi, any teams? Do we have any volunteers who would like to start? Yeah. Okay, I'm going to come to the first table. Have you appointed someone to present? Just a short 1 or 2 minutes is fine. Yeah?
Not me. We agreed that you are going to do it. Yes. You want to get up? I'm not the designated person.
We don't have a lot of time. We were told we need to wrap up in 3 minutes. You don't need to go into too much detail, just points is fine. So this all 3 tables, if anyone wants to add anything, just raise your hand and I'll give you the mic. Anyone else want to start? Here we go.
So we chose to answer question 1 based on case study 1. The first point we came up with is that, first of all, we have to establish the confidentiality between the client and us, whether it is a lawyer or whoever. And we have to ensure him that that confidentiality will never break. And that his sexuality, whatever it is, it does not matter. So we have to educate the person that the crimes that have taken place in this incident doesn't concern with his sexuality at all. So as a person, as a citizen of Sri Lanka, his rights are going to be protected inside this country, no matter what his sexuality or gender orientation or whatever it is. And first of all, we have to give him the chance to explain himself first, because now he has these preconstructions in his head about himself. So we have to get him to explain himself first before giving a legal opinion of the lawyer. And when handling situations like this, the staff should also be trained to handle such situations. And I believe that not just any lawyer can handle these types of situations, because those lawyers have to be patient and understanding and also aware of the rights that citizens of Sri Lanka may hold. And I also personally believe that the mindset of the lawyer also matters a lot when coming to handling clients of situations like this. And also the usage of the language between the client and the lawyer is also very important. And also, since in this case there is a threat about exposure of his intimate images, that also should be addressed. Despite the fact that he is only concerned about his money, there are many issues involved in this, such as assault, cheating, sexual harassment, pornography, accessing his bank details and all, and the fact that we can go to court procedures and get restraining orders and other legal options we have. So we have to educate him on those situations as well, even though he is just interested about his money.
Thank you so much. Yeah, you can go ahead. Just one top strategy is fine. Just one top strategy.
The main strategy is we have to ensure the physical and emotional environment of the client. That's the first thing. And also we have to increase the confidentiality of the client. And we have to use the language not to re-traumatize the client, because he's already traumatized. Therefore, we have to reduce the emotional questions and all. And also, we have to always give options to the client, whether he's like to go to police or the courts or whatever. We have to get the advice. Actually, we have to get the opinion of from the client before we proceed with any court case or police complaints. So these are the main strategies.
Okay, thank you. So I would like to ask this table to maybe give us one legal strategy. We don't have to go into too much detail. Just even point form is fine. Okay, that's fine. So I think there are common themes, and everyone is basically talking about how we can be more trauma informed. It's also important that we direct our clients who have gone through such traumatic experience to some sort of psychological support, because actually pursuing a case is a very daunting process for them. For someone who's not familiar with the legal system, it can be a very scary thing. So look at how you can support your client and direct them to some sort of psychological support. Yeah.
And let's go to case study 2. We have
We go to 2, just to show you that about 15 years ago, you couldn't go into an authority and say the gender or the sexuality of your client. But with work that's being done now, there are circulars the IGP has given on equal treatment for anybody, which means you can even in court stand up and say, this is my client, this is what they're like, and there is no issue. So that's the kind of effect you'll have with your work. Even if it's not black and white law, the system changes slowly. And so now it's accepted, and they are protected under these circulars. They can't be harassed. There is black and white circulars for it.
Okay, who's a nominated speaker in your group?
We are winging it. So for the for question 1, we were thinking of question 2. Sorry, no, question 1 in question 1 in case study 2. We were thinking of we need to help this lady get access to some psychological counseling and all, given the deep emotional distress she's under. We'll also try to see what if she's eligible for any like social welfare benefits or funds or whatever, welfare, financial schemes and all that. We also had discussed the possibility that if that 3-wheeler has been released, we can sell it. Yeah. And then that's question. The question 2. The first thing we'd have to do is try and make an application to get this case expedited, to see why it has gone on so long. Also, like we had a question why she's been like, we had to really raise this point. Why has she been named as the first accused? Because like, yeah, not dismissed. Yeah, it's some bullshit. And also like the mens rea and we have to establish that, you know, these are husband, like 2 randos, we don't know them. The husband's friends, yeah. So like we have to show that she.
So we have to prove that when she bought the tuk, it wasn't to aid and abet and facilitate this crime. It was just to help him to make some money. So we were also thinking
and
that,
you mentioned the first 4 days, if
yes,
there's any evidence
exactly.
that
So
actually has done some
the
hires or
crime
whatever.
happened after 5 days. So we assume that for the first 4 days that he was actually taking the tuk on hire, making her believe that, oh, he's changing. But it's only on the 5th day that he actually conspired with his friends and robbed. So, you know, she was completely blindsided, so she has no mens rea, so she should, if at all, be a witness, if at all.
This group, shall we find someone here for this case study 3?
Do you all want to add anything to case study 2? Yeah, okay.
For the second case study, the question number 2, as a legal provision, we can take steps under Criminal Procedure Code section 153 to discharge the accused, make a application in front of the magistrate, as the magistrate has power to discharge the accused if no crime is proven against. Yeah.
Thank you so much. Just to very quickly add the role of a private counsel prosecuting alongside the state, because sometimes the state is inundated, the police is inundated. So you have a very important role to go and keep speaking about her release and the evidence. That really helps the parties that have been wrongfully accused. Okay.
Can we now discuss case study 3? Any volunteers?
Yes. So we were assigned with case study 3. I'll briefly narrate the facts of this given case. So this lady had been caused to come to Sri Lanka.
We'll skip the facts. Give us one strategy or trauma-informed way you'll handle it. Top strategy or top.
She was wrongfully arrested in our opinion because on the grounds that she engaged in sex work. But
the law says that under the brothel ordinance number 5 of 1889, engaging in sex work is not an offense. But managing a brothel house, of course, tantamount to an offense under the brothels ordinance. So this wrongful arrest indicates sort of that the relevant authorities has not conducted due diligence on their part in correctly identifying the perpetrators of the said crime, because they haven't arrested the managers of the brothel house. They haven't arrested neither the parties who assisted, aided and abetted in this conduct, or rather the one who forcefully caused her to engage in this, and also the human traffickers. They arrested neither of those parties. So of course, they have not exerted due diligence in any form when engaging in this conduct. As well as since she is a foreign lady coming from Thailand, there should be an extra layer of protection. Particularly, they must take necessary steps, for instance, to inform the relevant High Commission that this arrest had been taken place. Of course, she has to give a chance to represent herself and a right to counsel, so on and so forth. And I would also like to incorporate section 360C1 of the Penal Code, which says that human trafficking is an offense. So of course she can avail assistance from those pertinent legal provisions existing under the domestic legal framework. And of course she is under the threat of being further threatened by the managers of human trafficking, so on and so forth. So of course under the Assistance to and Protection of Victim of Crimes and Witness Act number 4 of 2015, she must be given extra layer of protection for not being further re-victimized. Thank you.
Thank you. We're just going to move on to the next.
In the interest of time, I'm sorry that we can't ask everybody, but this was one of our biggest wins, because for the first time, the owner was charged for 15 years imprisonment and compensation for all of the victims who were trafficked. And they were all released and made PW witnesses, because you can't charge a sex worker in our country. Tilina Gamage has a very interesting judgment that if you're working to feed your family, that's not criminalized in Sri Lanka. For case number 4, yeah.
So considering the psychological support, I would say we'll have to get assistance from LGBTQ groups, because in Sri Lanka now there are many groups supporting these groups who have been victimized, and one is the most popular one is Equal Ground. So we can get assistance from that. And also I believe that as lawyers we could file motions requesting the courts to prevent media stations disclosing the information of these victimized people, especially their names, where they are working, and their family details. Everything should be disclosed. And also another important thing would be, it would be important if the court proceedings are conducted in closed courts rather than open courts, or in special courts which is not open to public. And when it comes to the legal strategies, we can always focus on the constitutional provisions. One is the right to equality, because we can clearly see that a lot of transgender and even gay communities, they have been arrested simply because of their identity. So that's just pretty much discrimination against them. And then there's a wrongful arrest here without any reasonable suspicion. They have been arrested for something they have not committed.
And not just that, the first complaint was not investigated. It was only, so it's clearly they have been targeted by the police because of their sexuality. So we're just going to move on in the interest of time. Yeah? Group 5, anyone from here?
In this case, police has repeatedly failed to arrest person named as Dinal. In this case, police has repeatedly failed to arrest a person named as Dinal. Regarding this matter, Sunil's sisters can lodge a complaint to Police Sahana Badiriya or Sri Lankan Police Commission. And secondly, Sunil and his family were assaulted by this person, so we can instruct her to or guide Sunil's sister to file domestic violence case in magistrate court. Also, this person, Dinal, is military person. He is going with a weapon. Sunil or his family can complain to a respective military department. In this case, the youngest child has been kidnapped by Dinal. Therefore, Sunil's sisters can lodge complaint to Child Protection Authority to guide Sunil and his family to be emotionally stable. We can guide them to meet psychological support.
Can we end with the case number 6? There's some law enforcement. Quick question and wrap it up. I think the next session is starting. Can we ask you your comments on case number 6? You can't hear the lady.
What do we need to say?
Okay, law enforcement. Who's going to speak on case 36?
First one. Sixth one, the first question. We have given the question that what are the strategies we can use to support Stella's immediate practical needs, such as access to shelter, finance, food, medical care, and safe transport. Since this lady was confined by her husband and there was some domestic violence happened and she was raped and the child cruelty also there. So we have separated into 5 elements that the strategies can be used to help her. The first one is the legal strategies. We sorted out into there can be a domestic violence case can be filed against the particular person, and there can be a rape case also filed with the support of the police officers, and the child cruelty also there. So the prosecution will prosecute with those particular cases, and the physical confinement also there. So we can do that. And for the safe shelter and the finance support, we can file a maintenance case according to the Maintenance Act for the particular person. And in help of, since she has no income sources, she can go for the financial support through the NGOs and the government organizations, so legal aid. So in the Women in Need NGO would be helping her for the particular supports. And also, since she is the Malaysian woman, we can go to the Malaysian High Commission to consulate supports, and they also will give her support through the financial support and the legal aids for her. So those are the strategies we find out for this particular person.
Thank you. Thank you very much.
And we have the law enforcement who want to make a quick comment.
Okay.
Yeah.
Yeah, we would going to get the support from the JMO, and as he mentioned, we going to get the protection order under Domestic Violence Act, and we have the Victims Protection Authority, and we would go to the provisions of that act to apply this case. My colleague will explain in detail.
Yeah, in addition to that, we can rely on with the Domestic Violence Act, where it says, the section 12 says about the supplementary order, then section 10, it says about the protection order. So through these sections, we can give her, get her full protection. Also with the JMO report, as he mentions that she has got raped several times by her husband. So in this case, through the JMO examination, we can get to know actually the rape has happened or not. Then the other one is through the JMO reference, he may refer to the psychiatric session or not. So that is a case. In addition to that, for the child protection, or in case if she need the child to be with her, then we can go for the custody. In addition to that, there are any other one is the Maintenance Act, where the section 2 says she has a right. So that is what we have discussed. Thank you.
Thank you, thank you. Case study 6, for those who haven't read it, was a horrifying case of a husband torturing and raping his wife. But did you know that under Sri Lankan law, a husband can legally rape his wife? Do we think that's a just law?
No.
I know, you can't, yeah. Do you think that's just? No. So we should change these unjust laws too. But thank you very much. I hope you really realize, what incredible impact you can have to change people's lives with pro bono work. If anyone wants to sign up with iPro Bono, come for our trainings. Please let the committee know, and we'll love to have you on board. Thank you. Thank you, everyone. And thank you to my team. Thank you so much, Shamindri and Jerusha. And thank you to all of you. Great work.
Thank you, Mr. Arita Wickramasinghe from iPro Bono and his team consisting of Ms. Jerusha Thambaya and Ms. Shavendra Manuel. I would like to invite Mr. Tisha Veragoda, Chairman, Junior Bar, and also Mr. Sanun Batagoda from the Sessions Committee to hand over our tokens of appreciation to the panelists who did this wonderful practical session. Everyone, we would like to remind you to please be seated as the next session with the esteemed panelists, which all of you are waiting for, is going to commence in a few minutes of time. And also, we would be distributing a form to these tables where you will be able to register as panel lawyers and conduct yourself with the Legal Aid Commission in proceeding forward. Thank you.
I invite our guests to take their seats as the sessions will commence shortly.
Good morning, everybody. The third session for the day will be commencing now. The theme revolves around this session, from brief to bench. Your moderator for the day is Mr. Kanil Madhumage, attorney at law. Mr. Madhumage was enrolled in 2015, holding an LLB honours from the University of London and an LLM from the University of London. He serves as a visiting lecturer at the Faculty of Business, University of Moratuwa, and counts a decade of experience in both original and appellate courts. Without further ado, I now invite Mr. Kanil Madhumage to introduce the members of the esteemed panel for the day.
Good morning. His Lordship, Honorable Justice Thuray Raja, President's Counsel, Judge of the Supreme Court, dear seniors and my dear colleagues. This session is named as Brief to Bench. What do you mean? What does it mean? Now, as juniors, you will be working under a senior for a particular period of time. Then you will start your own practice. From the point of receiving a brief or client retaining you for a matter up to the point of filing the case in a court and arguing the matter and getting your reliefs, there are several steps that lawyers have to follow. There are good practices, there are things that we should not refrain from doing. Today we have a very esteemed panel who will be discussing what are the pre-litigation options you have when a client retains you. Then if you decide to go to litigation, what are the steps that you need to take? Then if you have to prepare for the case, how you prepare for an argument or prepare for a trial, or prepare to support an enjoining order, bail application, or leave to appeal application in the Court of Appeal of the Supreme Court. Then, most importantly, we have an esteemed Honorable Judge of the Supreme Court who will provide His Lordship's insights on how a judge sees you. That is one of the very important things for a counsel to know what the court expects from you. Because we can get advices from our seniors, we can get advices from our colleagues, but it is very rare for you to get an opportunity to hear from a sitting judge of the Supreme Court what the judiciary expects from you. So I believe in that perspective, this session will be very helpful for you. Let me introduce our resource persons or panelists today. Dr. Sarani Gunatilaka will be doing the first session. She will be discussing on the introduction to negotiation, mediation, commercial mediation and arbitration. Dr. Sarani, attorney at law, is an internationally accredited mediator specializing at the intersection of dispute resolution, law, human rights, etc. She is the CEO and co-founder of the UDecide, a pioneering mediation platform based in Sri Lanka. She is accredited as an international mediator by the Singapore International Mediation Institute, Indian Institute of Corporate Affairs and several other institutes. Dr. Sarani is an experienced negotiator who will be discussing about pre-litigation options that you have when a client retains you. Then we will be moving on to Ms. Dasuni Vijayawardena, who is a partner of the esteemed DLNF Deseram legal firm. She was called to the bar in 2009. She holds an LLB from the University of London and an LLM in Commercial and Corporate Law from the Queen's Mary University of London. She will be focusing on the role of the instructing attorney what you should do and what you should not do as an instructing attorney. In fact, Honorable Justice Thurai Raja was discussing with Dasuni and me the importance of the role of an instructing attorney. Sometimes we forget. We only think about the counsel. We don't know the agony or the difficult task the instructing attorney is having. There may be juniors who are working for firms. There may be juniors who are working for senior instructing attorneys. So this will be a good opportunity for you to learn the basics on instructing work. Then we have Mr. Nirmalan Vigneshwaran, who is a Deputy Solicitor General at the Attorney General's Department with a service of over 25 years. Mr. Vigneshwaran holds a Master of Arts in Law and Diplomacy from the Fletcher School of Tufts University and a BSc from the University of Colombo. Mr. Vigneshwaran is a familiar face in the appellate courts, especially in the Supreme Court and the Court of Appeal. You often see him arguing and matters in the Supreme Court and Court of Appeal. Mr. Vigneshwaran will focus on the craft of counseling, especially how to effectively prepare for a case and structure arguments coupled with tips for presenting effective arguments. Then the most important session, we have Honorable Justice Thurai Raja, President's Counsel, Judge of the Supreme Court. His Lordship joined the official bar in 1989 as a State Counsel, and he was gradually rose to the position of Additional Solicitor General. His Lordship was appointed as a President's Counsel in the year 2016, and in the same year, His Lordship was elevated to the Court of Appeal. Thereafter, His Lordship was elevated to the Supreme Court in the year 2019, and I believe His Lordship has delivered more than 300 judgments as a judge up to date. And His Lordship is a member of the Council of Legal Education and Commissioner in the Judicial Service Commission. His Lordship is the most senior sitting judge in the Supreme Court of Sri Lanka. As I informed earlier, His Lordship will focus on providing insights into the courtroom expectations and highlights the importance of viewing a problem in an out-of-the-box manner. And thereafter, there will be a very interesting session. I don't want to disclose what that session is. I kindly invite you to remain until the conclusion of the session, and you will learn something practical and important after this session. So I cordially invite all the 4 panelists to take their respective seats so that we can commence our session. The first session will be conducted by Dr. Sarani Gunathilaka, and this session will focus on making the choice of ADR and exploring the non-litigation options. Dr. Sarani, I cordially invite you.
A very good morning to all of you. Permission from His Lordship and the esteemed panelists. First, my thanks go to the organizing committee for coming up with this theme. When I heard the theme, I was actually quite surprised because the thinking behind the theme matters a lot. It's a very well thought out session because as juniors, it really matters to us as to how this process goes and what challenges come in the way. So, good job organizing committee on that. So, in my session, I know Kanil said I'll try to introduce mediation, arbitration and all of that. But I think I'm actually not going there today since we have about only 15 minutes. I thought let's try to address one of these myths that we think about when we talk about ADR. Because we often look at ADR as something that we have to go with, you know, other than litigation. That ADR only comes into play if you're not going into litigation. So I thought I want to address that today, so that's why I have named this. As you can see, it's not alternative dispute resolution that I want to talk about, rather appropriate dispute resolution. And beyond litigation, how do you go into that? All right. So I have a question for you at first. I'm going to go back. Let's engage a little bit. When you get a dispute, let's say a client comes to you and asks you or tells you, I have a problem. What is the first thing that will work in your mind? What will you try to first identify? If somebody comes and tells you a dispute, what is the first thing you would want to identify? Fees. Yes, sir, that's a very honest answer. Yes, to get fees, what will you first think of? If you're thinking of going to court, what is the first thing you have to identify? In the case that they are presenting, what will you look for? Cause of action. I heard somebody said it. Okay. Okay. Yeah. So that's how technically, as lawyers, our brains should be wired, technically, okay? Because if we can't identify the cause of action of whatever that they are saying, can you file action? No, you can't. So technically, usually, when a client comes to you and they start talking, our brain should be going, where's the cause of action? Where's the cause of action? Which section? How am I going to file the case? Our brain should be, constantly working on that. Correct? Yeah? Okay. Now, what I want to propose to you is, what if we don't do that? What if we switch it off for a moment? Then the question is, then what are we supposed to do? Right? Because that is what we have been taught. So here is where appropriate dispute resolution comes in. In appropriate dispute resolution, we don't listen to a client trying to understand a cause of action. Because the moment we do that, we are thinking of litigation. So often our answers to the client would be, okay, we can file this type of a case, or we will say, oh, you're late. Now you're time barred. Or we will say, I don't think you have a case. Because the cause of action requires at least for us to establish A, B and C. You only have B and C. Unless we make up A, there's no case for you. Right? So these are the standard answers that we would have when a client comes to us if we only think of cause of action. So in appropriate dispute resolution, we try to switch that button off. Okay, I'm not looking for the cause of action, but I'm still trying to understand what the client is telling me. Okay? When listening to a client, what are we really trying to then understand? Okay? Instead of thinking of the cause of action. So this is often very popularly referred to as, it's taking a bit of time to go, but that's fine. It's all right. I hope I can give you some visuals, just by giving you some examples. So when a client brings you a dispute, we say we have to act as a doctor. What does a doctor do? When we go and tell them our disease or whatever the symptoms we have, what do? They diagnose, right? So then for us, as lawyers, we also have to act as doctors, dispute doctors. Listen to them without prejudging that this is a case that has to go to court, therefore I have to look for cause of action. Now, oftentimes we don't do this knowing that we are doing it. It's an automatic reaction that happens in our brain to find cause of action. Because that's our legal training. We have been trained to do that. So if it happens in your brain, good, that means you're doing it right, the way you were taught. Appropriate dispute resolution asks you to pause a little bit, take a step back, listen to the dispute to understand the dispute. Why is it important? Think for a moment, if you go to a doctor and before you sit down, if the doctor says, the moment you say, oh, I have this stomachache on this side, what if the doctor suddenly goes and says, oh, we have to do an operation? Operation, 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 he doesn't want to listen. Sometimes you might be having this because you fell down and you knocked it somewhere, right? But if the doctor is predetermined, he will prescribe you something that does not solve your problem. That might even aggravate your problem. So similarly, as lawyers, if we are predetermined, when a client comes to us, that case is a case that has to go to court, therefore I have to think of cause of action, we might take people to court for matters where actually a court decision cannot give them a solution. Do you agree? I might be saying things that you can't agree, so if you don't, you can tell me. We can have a conversation about it. Do you think that can happen? That you can take people to court when the court decision can't give you a solution? No? Yeah? I only see Tisha nodding, so... but yeah, so this can happen, and I think Justice Suriraja will also tell you sometimes, I mean with all the experience that we see in court, you oftentimes see that sometimes people are before court and court thinks, what are we supposed to do? Is this something that you should have come to court? Aren't you wasting court's time? There are enough and more applications like that pending before courts, sometimes for years. Yesterday I heard that in one of the courthouses, there's that famous dispute, since court hearings are public, I can share this, that famous incident of, one beauty queen pulling off another beauty queen's crown case, taking hours and hours of court time, among so many other very crucial matters. And nobody knows at the end what is going to happen. Is one beauty queen going to go to jail, or I mean, how are compensation going to address this problem? So many issues. Now I'm not saying they shouldn't have gone to court or anything. I just gave an example that so many types of disputes can go to court, and you might not know in the end why did we go to court. You forget it, right? So in those instances, it's very important for us to take a step back and really try to understand what the dispute is. This is called dispute diagnosis. Just like you diagnose a disease, you have to diagnose the dispute. When you diagnose a dispute, you will identify two things. Certain things are visible at the very outset. For example, you walk on the road, you see two people fighting, one people falls down, injury, visible. Simple hurt, grievous hurt, you can name it, that is what is visible. But there could be things that are not visible in that dispute, things that you do not know. So sometimes the case that you take to court will only address the part that is visible in that dispute and not the part that is not visible in that dispute. You might end up giving a decision through a court for the visible part, but the invisible part will remain unsolved. Therefore, you will see repetition. So it's sometimes very difficult, unless deterrence works very well, it's very difficult to prevent recurrence otherwise. Now we all know punishment is one of the objectives is deterrence, and therefore thinking deterrence will stop people repeating. But how true is that? Again, Justice Surirajan, if you practice in criminal court especially, you would know the number of times same suspect comes or doesn't come because he's in another courthouse. So then you're wondering, how many times does this person do this? So how far has it worked is a problem. So all of these things are about identifying the problem properly to give the proper solution. I'm sorry, it's... okay, it went. Yeah. Here. Yeah. So I just wanted to show whatever that you can see from the outset are often your legal positions. What you can't see are your actual interests. Now, if I give you an example, in one of the mediations that I have done, I can't give you details because of confidentiality, but that was a case that was before the Commercial High Court, a construction dispute. If that case was not to be settled that day, there were 13 other cases waiting to be filed. Okay, so you know that if I don't settle today, 13 other people are going to join force and file cases. But when we had the mediation, they posed the case in court and came back to mediation. In the mediation, we realized one party's key interest was that it was a matter with regard to an apartment, that they had a father who couldn't take steps because he was very old. So their main interest was to somehow get the lift done. But they had come to court on several construction contract clauses, they were arguing, interpreting clauses, which interpretation is right. But the behind interest was basically get the lift prepared faster so that the father doesn't have to wait. We identified it in the mediation and the matter settled. It didn't take so many days, it only took about 6 to 8 hours. At a stretch, we did the mediation, case was settled. No 13 other cases. Parties actually got their interest addressed. They now know the contractor is now going to finish this. Contractor had some problems. They got together and decided of a mechanism how to address the difficulties contractor had. Because ultimately, contractor want to finish the building, this person want the lift done. It's fairly a common interest, and we gave a very different, creative type of a solution that addressed this interest. So, just an example of how important to identifying this underlying interest before you decide on the method of resolving disputes. Now, when I say all of this, all of you will be like, oh, so you're telling us not to go to court. That won't do. We took courts, we have to go to court. I also go to court. Okay? Now, just because I tell you to mediate, it's not that I don't file cases. Of course, I file cases and I argue cases. So, those who know me know that, I'm also very, if I have to argue something, I'm also very for it. I can also argue. It's not that for every single case you have to, stop litigation and go to mediation. That's why we title it as appropriate. When you become a disputes doctor, you listen carefully to understand what is the disease for which I have to operate, what is the disease for which I have to just give a tablet and see. So you can decide on what to do, which option to take. That way you become a disputes resolution strategist. From a doctor, you come into a strategist position. Now, if you really think about all our senior lawyers, they will all tell you that they are all successful because they are strategists. They are not just litigators. They are all strategists because they know, for this case, I am filing the case, but my client's reliefs will not come by way of a judgment. They will most probably go, get an interim order, get a stay order, make sure that the pressure is transferred, then they will propose, now let's negotiate. So then they use the tool of negotiation. another tool, right? Some will say, let's mediate, because the two parties have very high egos, no way they are going to settle in negotiation, so we'll use a third party. So likewise, in dispute resolution, appropriate dispute resolution is always about becoming a strategist. I know I might be running out of time, so I will just leave the other slides because they are more on law. I just wanted to tell you that if you really think of the UK legal system, just as an example, that this is not something that I am thinking and telling you, in the UK, civil justice system is based on this principle. In their civil justice system, trying out ADR is so embedded in the system that since 1998, after Lord Justice Wolf suggested that incorporate ADR into civil law, they incorporated into the civil procedure itself and said if the courts are to achieve the prime objective of efficient and effective delivery of justice, ADR has to be followed, but not as an alternative, but as an appropriate method of resolving disputes. I'll stop with that. Thank you very much.
Thank you, Dr. Sarani, for your insightful thoughts. Now we move on to Ms. Dasuni Vijayagunawardena, who will be speaking to you on the role of the instructing attorney. We have named this session as a very interesting topic, behind the scenes. Actually, even though it is termed as behind the scene, a lot of work is being done by instructing attorneys. I think she will enlighten you on the role of the instructing attorney. Ms. Dasuni.
His Lordship, Justice Raja, distinguished panelists, ladies and gentlemen. Having sat in for the previous session and this session and have heard some wonderful ideas about approaches to dispute resolution, permit me for a bit to take you back to traditional dispute resolution and litigation. And out of that, I will also be talking about the role of an instructing attorney, as Khalil said. Now, all of you are at the beginning of your careers. I presume some of you do work for instructing firms or do instructing work or are instructed by instructing attorneys. So I'm sure you have a rough idea of what it means to be an instructing attorney. But at the very outset, I'd like to say that there are, unfortunately, some, shall we say, stereotypes and misconceptions about what it is we do. Now, an instructing attorney is somebody who is a lawyer, who is responsible for the efficient coordination and administration of a case through the dispute system. And the way we approach it in a multi-pronged fashion. You are the face to the client, you get your instructions from the client. If you retain counsel, you give instructions to the counsel. And as an officer of court, it is your responsibility to give your client the best case, fight their cause within the principles and values as enunciated in our profession. And this point has been actually made in a recent judgment by the Supreme Court. I've put it up on the slide by Justice Arjun Obesekara, where he talks about the nexus an instructing attorney forms. There is a nexus between us and the client and between us and the counsel and our overall obligation to court. So I think many of you would also think, I mean, you're just filing papers. But do you know the weight of responsibility that stays behind every paper you sign, every proxy you take ownership of that dispute. You shepherd that dispute throughout court. And it's not a responsibility that has to be taken lightly. There is a lot of seriousness and a lot of appreciation of the professional standards that you require for this. So, on that note, given the time that we have, I mean, the depth and the breadth of the civil law and commercial law is wide, I just want to give you a few practical insights on what it is we do. So starting from the namesake, instructing attorney. What is it we do? We take instructions. So when a client comes to you, Your first job and your most important job is to get a full comprehensive set of instructions. And when I say full comprehensive set of instructions, remember your client is a layperson. It is your duty to gently guide them through, hear them out, actively listen with empathy, and see what is the best possible course of action, not cause of action, for them. Now, as Sarani pointed out, sometimes we have a reputation, some cases are filed as with a different intention in mind, with no visible, maybe, cause of action, or no actual goal of establishing. Dare I say that one part of our job as an instructing attorney is to actually listen and advise our client what is best for them. And with the advent of ADR and mediation and arbitration for the last couple of decades, one of the things that I must say in practice that we actually do, instead of automatically cycling off to litigation, is we look and see what is the real meaning behind this dispute, and that is how you should act. One of my professors actually told me a very interesting thing. He told me that litigation boils down to two reasons: money or pride. So I think finding the ultimate motivation, as Dr. Gunapalika said, is extremely important. And as attorneys, we must remember, filing a case is a means to an end for the end that the client wants. When you get your client's instructions, ask the client, what is it you want? And after hearing the client, make that considered decision, put it towards the client, let them make an informed decision on where this is. Because litigation, let's face it, is stressful. It is time-consuming, it can cost, and the emotional burden most clients carry, given the length of proceedings. I am being very frank here. While a client may come to you highly enthusiastic at the beginning, as the case, as it sometimes does, drags on, sometimes for reasons beyond even your control, that enthusiasm fades. And that enthusiasm, I mean, and I'm speaking very frankly here, can turn to resentment and frustration with the system. And that does nobody any good. So I think the first thing we must say is when you get your instructions, speak to the client, listen to them. I think this is something I can't emphasize more than enough. Listen and hear them. As juniors, you may sometimes, and a lot of my own juniors do ask me, how do I know what questions to ask? And that is something that comes with practice. The next thing actually I'd like to bring up is fine. You decide to go to an instructing attorney. Pardon me. Pardon me, my voice is not the greatest today. How do you brief a counsel? Briefing a counsel, again, I'm being frank, is not just literally dumping a whole pile of documents with no rhyme or reason. You go through, what we normally do in our practice is we ask the client to give us, we normally ask for written instructions, as is good practice. We go through the documents and we encourage, and I would encourage all of you, to make a chronology of events and compare it with the information that you have. That actually helps you to see any gaps, any inconsistencies, or any information that you might need to know. Sometimes an example might include you get a plan for a land dispute. The plan refers to an amalgamation or subdivision number. It's your job to ask, where is that plan? Maybe it's relevant, maybe it's not. But the fact of the matter is, it's your initial instructions that will shape and define the case for what comes forward. So you need your information. Another example is, your client might casually mention a name and say, someone did this, or I got a letter like this, but it never comes up again. And to avoid a technical objection for non-joinder, misjoinder, you might have to ask, who's that? So I know these sound very basic, but you'd be surprised of how proceedings have probably gone on for months, years, halfway through trial, and it appears that a crucial fact was missing because, well, the client, being a layperson, understandably didn't think it was important, but it actually was. And sometimes a technicality could even be fatal in such a situation. The next thing, I'm talking of alternate dispute resolution methods. If you do commercial disputes, you will inevitably end up reviewing a contract, an agreement, And the first thing you must do, again a basic thing, check if there's a dispute resolution clause. Check if there is a pre-litigation procedure. Nowadays, most do. Check if there is a jurisdiction clause. Because, as you know, if there is an arbitration clause, there are sometimes limitations under Section 5. If there is, and if you're taking action against a particular entity, a state entity, for example, there are notice requirements you may have to do before this. Some contracts have mandatory negotiation periods, and certain industries also have specific dispute resolution. I think construction comes to mind. There are adjudication boards, etc., which would, more often than not, you would be expected to comply. Similarly, the next important thing you need to ascertain at the very outset is who are you filing action against. Filing action, and an instructing attorney's job in filing papers, is also to ensure that the party you're filing action against is given proper notice and served through court via the sections of the Civil Procedure Code or the Supreme Court rules, as it may be. When a client tells you, this is the person I want to file action, this is his address, it always does a lot of good to verify that. There have been time and time again when envelopes and notices are returned with incomplete addresses, incorrect names. Not only are you wasting your client's time, you are also wasting the court's time and the processing time and actually prolonging the dispute. So constant diligence on even small matters like this is very important. So the other thing I would actually like to say is when you're briefing counsel, you've done your chronology, you've done your documents. I cannot emphasize more how much you can assist counsel, but when you brief them, give them a briefing note. Consider the dispute. Be the instructing attorney who is actively involved as you are supposed to be. Be there for the consultation and have that discussion. Your relationship with counsel, it's a two-way street. There must be effective communication, as is with the client. You and your counsel must be on the same page. You must be able to effectively communicate those instructions to him. And that I cannot emphasize how important that may be. So, when it comes to filing procedure, the CPC is your friend, the Supreme Court rules are your friend. Start from that, start from your source of procedure. I recommend that anybody, not just people who are just starting out, even I do it myself at times, when you file an action, write down what the substantive law is, write down what the procedural law is, and very importantly, check, has that law been updated? I'll give you an example. Over the past couple of years, we saw several cases where we raised objections on in appeals filed against orders, or judgments rather, made for purging default in ex parte cases. As you know, you are entitled to purge your default under the Civil Procedure Code, but until I think the 2022 Civil Procedure Amendment, the process was thought to be a final appeal. But after the 2022 amendment, a clause was specifically inserted into Section 88, where they said leave needs to be had from the High Court in the first instance. And unfortunately, in some cases that did not happen. People filed notice of appeal and then petition of appeal 60 days later when this provision was subsisting. And it was only a matter of going and taking up that objection that appeal was invalidly made, rather, and of course that client lost that opportunity. So procedure may seem, how can I say, standard or even dull or routine to some, but procedure is the vehicle by which you present your dispute. It is a means to an end, and every procedural step, I know it doesn't sound particularly exciting when I put it like that, but is there for a reason. And you are doing your duty to your client by making sure the case is put through effectively and in the best possible way. Just a few minutes ago, when I was having this conversation with Justice Thureraja, and I also agree, one of the things that we need to do when we prepare briefs to court is we need to be mindful of how the court perceives the brief. Just lumping documents together in any old way, without much care, would not really help your client advance their case. And on that point, I also need to say, in addition to formal rules, have a relationship with the registry. Each registry has their own specific maybe ways and means of processing. Here I talk about things like voluming, page numbering, which when you think about it is common sense. You want to make your brief, your case as accessible as possible. And going back also, yes, you may be going through a trial, you may prepare, but at the end of the day, listen to what your client says. And as it was pointed out earlier, sometimes what the client wants doesn't quite gel with the relief as set out in the law. In that situation, if the client is willing to explore settlement, and as you know, in pre-trial and in most courts, the possibility of settlement is discussed. Mood it to your client. Be open to that. And please, and always keep an open mind. I think I'm running out of time, so I will just conclude at this point. Remember, an instructing attorney is effectively a guardian of the client's case. It is, to quote this court, an onerous responsibility. And that said, I will end with saying to all of you, master the fundamentals, stay diligent, and you will find this role, though demanding, is rewarding and fulfilling. With preparation, patience, and curiosity, you will grow into this role, and our profession will be better for it. Thank you.
Thank you very much, Ms. Dasuni Vijayasirivardhana, for sharing your knowledge with the audience. I think instructing attorney is a very rewarding career if you do it very correctly. So we can discuss about this in the questions and answer session. The next session is the craft of case preparation and courtroom advocacy. Mr. Nirmalan Vigneshwaran will talk about how to effectively prepare for a case and structure arguments. And he will give you tips to become a successful counsel. I cordially invite Mr. Nirmalan Vigneshwaran to address the gathering.
Good morning, everyone. If there's one thing you can count on, that's technology will let you down, right? Okay. This one to move forward. All right. So I made sure that the judge on this slide doesn't look at all like Justice Tureraja. So let's go through this. I just want to take you guys through a few things which have helped me. Right? So let's go through it one by one and see how we can come up with ideas on how we can become better counsel. Okay? Does anybody know this gentleman? Anyone? He appeared in the in numerous cases. That's right. So it's Dr. Colvin R. De Silva, right? He was a brilliant counsel, both in the original court and in the appellate courts, a strategist, brilliant, right? Now he said, he spoke of the three most important things, right, in a case. Three most important aspects in a case. Would anybody like to take a stab at it? What is the first, the most important thing? Sorry? Facts. Okay, very good. Anyone else? The judge. That's the most important thing, according to him. Right? What is the second most important thing? Yes? It's the judge. And what's the third most important thing? It's the judge. Right? You know your judge. That is the most important thing for you, for your case. Right? So, as an advocate, as a counsel, what is your goal? Your goal is to convince the judge, to persuade the judge to see your point of view. Right? For the judge has to understand your point of view. That is your objective. So in order to do that, for you to communicate, you need to know what the other person is about, what that person is thinking. It is only then that you can convince that person. Right? So if, for example, if the judge doesn't understand it, if the judge doesn't get it right, it's not the judge's fault. It's our fault. Because we have to communicate it to the judge. Right? I remember a case in which I was appearing, and my excellent junior was really annoyed with me because I kept apologizing to the judge because the judge just didn't get what I was saying. And my junior, who was a very, very bright officer, tugged on my gown and said, "Sir, stop apologizing. He's the one who can't understand this." So then after court, I said, "Look, it's not his fault. It's because I didn't present it in the right way." Right? So we have to be devoid of ego and try our best to ensure that we are able to communicate. And we have to always remember, in our minds, we think we are the person on the left. You have to be ready for the judge and the rest of the whole staff to think that you look like the image on the right. Right? So what is in your mind? You might think, I'm the most eloquent counsel, I'm doing this, I'm doing that. Bear in mind, everybody else might actually see you like this. Okay? So let's start with a few key skills. I've just thought we can jot down a few key skills which I have found useful. So the first one, as I said, study the judge. So what are the judge's views? What is the personality of the judge? What are the judge's preferences? Right? So for example, Justice Obesekar, for example, likes tables and charts. Right? So when you're going in there, it's good to go with that. Then look for statements. Now one judge who is present here in this auditorium says things like this: only Nirmalan and the Inland Revenue wants to tax everyone. So what does that say about that judge? Right? So of course the moment he says only Nirmalan, you know he's joking. Right? So you need to know, okay, what is it that the judges, look at the statements that come from the judge. What is behind it? Are they being serious? Is there a serious concern? Right? Do they feel that you are being unfair? Right? Then look at, it's not just what they say. Look at their facial expressions. Look at their body language. Sometimes when you have 2-3 judges sitting, the two judges who are maybe having a similar view, you can see they might, lean closer to each other. Then you know, okay, these two people perhaps are thinking the same way. If you see them waiting like this next to the other person, then you know maybe there is not, all is well on the Western Front, right? Then keep observing. Now when you are making submissions, you are trying to see if your message has been appreciated by the judge. Does the judge understand it? Look for clues. When your opponent is making submission, look for clues. Even in the case before your case, maintain eye contact and see what the judge is doing. Right? The previous case, the judge might have gotten annoyed because somebody comes and messes things up. So when you start up and you start making submissions, that there might be a residue from the earlier case. So you know, okay, this is not for me. This is because somebody else came and messed the whole day up. Right? So you have to, it's a conversation which starts from the very moment you go into court. Okay? No detail is insignificant, just keep looking at different things. Right? Is the judge looking at his watch? Right? That means maybe he's hungry. Right? Hungry judge is an angry judge. Right? So you need to be mindful. Okay? Then, so before I go into the next part, I have a slight disclaimer here. Okay? It is, right? So I try to classify judges into a few groups. Okay? So the first one, these are the judges whom I call difficult judges. Okay? In my mind, I categorize them into these categories. Okay? Number one is the coitus interruptus. Sorry, quite the interrupters. Okay? Or you can call them ill-tuned cymbals. Right? Then you have the Zen monk or Rip Van Winkle. Okay? Nothing, it's just absolute calm, nothing. Right? Then you have the crusaders. Okay? Then you have the heroes. You have the disposers, and you have the bullies. Okay? These are the difficult types of judges. The other judges, no problem, I think we can manage. Okay, so these are some of the things that I try to do with these kind of judges. Okay? So when you have the judge who is an interrupter, who interrupts your submissions, for me, that is the easiest kind of difficult judge. Why? Because you know what the judge is thinking. Then you can respond to it. They are humans, they have problems. They are problems meaning they have problems with your case. So they are asking you questions. Use that as an opportunity, right? So reminder skill 1, why is the judge, you have studied your judge, why is this judge being impatient? Is it that he doesn't understand? Does he disagree with the principle, right? Has he already decided the issue? Try to use that to decide why is it that they are asking these questions. And as I said, interrupters are not difficult judges. It is a wonderful opportunity for you to address their concerns, right? Then another thing which is very useful, particularly with judges who are maybe impatient or who would like to interrupt, is for you to have a structure of your argument. So I like to have it like this, like say point 1, under that you will have 1A, 1B, then under 1B you might have 1B1, 1B2, 1C, point 2. So you have, it is in movable blocks, right? If the judge says, no, I want you to tell me about this, point 2A, right? You go straight to point 2A. You don't need to go like a diesel engine where you have to go and get to that point, right? You can just go straight to point 2A or 2B and then come back to point 1A or 1B thereafter. Okay? Then you tell your structure ahead of time to court. You say, look, this is my structure, this is how I'm planning to do it, so that court knows you will get to these points. Right? I find having separate sheets of paper quite useful. And if a court says, look, deal with point 2, you can say, I will deal with point 2. Can I finish 1 and come? If they say no, go to point 2, right? Anticipate. That's another important skill. Try to figure out what judges might ask. That again goes back to the type of judge. What is it that will be there in his mind? For example, this is with Justice Tureraja, this is what I anticipate. He wants to know is what the bottom line for him, most of the time, is the state doing something reasonable? Right? So my entire argument, I will anticipate his questions are going to be on, look, are you being fair? Right? No point in my trying to come up with random theories and all of that. Bottom line, is it fair? So I need to structure my arguments to show, look, what we are doing is fair. Right? Then don't argue with the judge, particularly if the judge was a counsel before that. The more you argue with the judge, it will bring out his competitive tendencies or her competitive tendencies, right? Then stay calm and think, right? Sometimes you get a googly. You haven't been able to anticipate this. Think the question through. What would be the follow-up questions? Don't immediately answer the questions. Think it through, right? Don't bluff. If you don't know, be honest. Say, I don't know this. I can put it in my written submissions. I can get instructions. Do not lie, right? And do not try to bluff. Don't dodge the questions. Sometimes people don't answer the question, right? So always try to answer the question directly. And don't say, I will come back to it, and then not come back to it. Of course, there are some questions where you might not have a yes or no answer, right? For example, if somebody asks you, have you stopped beating your wife? You can't say yes, you can't say no. Right? That is because there is a problem with the question, right? So then you might have to explain that to the judge, right? I find this judge the hardest because either they are not concentrating or they are a blank wall. So you don't know what they are thinking, so you can't communicate with them, right? So you see if you can try to engage the judge, C for different line of argument works. If it's a Rip Van Winkle kind of judge, avoid the afternoons, that's the worst time, right? Then maybe you can ask a polite question and try to get the draw the judge into your argument. Worst case scenario, forget about that judge and move on to the other two judges who are there, if that person is too far gone, right? Then you have the crusader, right? So the crusader is coming with a plan saying, I want to change this, right? I am going to make this country the greatest environmentally friendly country. Every right, women's rights, or children's rights, or whoever's rights, I am going to do this, right? So be mindful. See, why is it? What is it, the issue or is it the facts? If the facts are what is triggering the judge, try to see if you can maybe go on towards the law. If it's the law that is triggering the judge, see if the facts can be used to your advantage, right? Most judges, almost all judges, they have a sense of justice. They want to do the right thing. That is what drives them, right? So see, and sometimes if they feel that you are trying to do something unjust and unfair, they will twist the law to try to ensure that justice is done. That's a natural feeling of judges. So give a way out to the judges. Tell them, look, okay, I understand your problem. I will solve that in a different way. So give them an opportunity so that they have a way out. Then you have the hero, right? The judges with hero complexes. Okay, so you have to be very careful there, right? These are the types of judges, sometimes they want to be the center of attention. Even if it is a funeral, they want it to be their funeral, right? So yeah, we have to be very careful with them. Don't try to make any jokes. Don't try to do anything. All the jokes should be the judges. That person is the one who is going to do. You have to learn to play second fiddle, right? You have to be mindful. Don't even come with your final point directly. You just go around it so that the judge says, so what you're saying, isn't it this? Then you said, yes, my lord, that is what I was saying. So as if the point has come from the hero, right? Not from you. So then the judge will feel like it is his point and he will work on it, right? Then you can thank him for coming up with that point and, right. Then you have the disposer who is not concerned about anything else. He just wants to get the case done and go home, whatever. He is just, I'm not interested. Tak, 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 done, go, yes. You can say what you want, he's not interested, okay? So for those, it might be just a question of efficiency. So go back to our key skill 2, have a clear structure, and just remember, maybe you need to just simplify the arguments. Try to come up with, limit it to, you might have had 10 points, but actually you need only 3 points, right? So you don't need to do all of this. Limit it to the main argument. And then you have, maybe you can think of sound bites. You don't need to give a complex argument. You have to sometimes think a lot beforehand, what is the word I can use to capture the attention of this judge, right? Then of course you sometimes have the bullies, right? So very few, but sometimes you get them, right? So you try to project confidence, right? Like any bully, a person who is not, they won't, when you project confidence, the judge doesn't really try to be mean to you unnecessarily, right? Don't react, right? So, and then be firm, but be polite, right? Whatever the judge does, you have to be polite. But you have an obligation to your client, you have an obligation to justice, you have to be firm, but absolutely polite, right? And keep your senior informed. Look, there was this problem. Don't be afraid to ask for help. So these are the types of difficult judges with whom I think you might want to, you might encounter in your day-to-day practice. So I have only dealt with the judges. There are other areas to this. Like there is preparation for facts, there's preparation of law, there's preparation in relation to the opponent, and there's preparation in relation to the witness. But because there isn't enough time, we will stop this here, and then maybe we can have a chat later on. Thank you very much.
Thank you very much, Mr. Vigneshwaran, for that wonderful speech with practical examples. I think we all learned a lot. Thank you, sir. Then we
Act number 9 of 2023. For this session, we have an eminent panel of panelists who will be taking their seats in a short time duration, and they will be taking their seats shortly, and I would like to invite Mr. Asela Serisinghe, who is the moderator of this session, to give the formal introductions of the panelists. Thank you.
Thank you very much. So this session is a criminal law session, and I will be very brief in my introductions because the speakers that we have today need no introductions at all. We have Mr. Anuja Premaratne, President's Counsel, all of you know, and Additional Solicitor General Ms. Haripriya Jayasundara, President's Counsel, Mr. Ashoka Veerasurya, Senior Attorney at Law, and of course Mr. Ranil Samarasuriya, Attorney at Law. Can I please invite all of you to come and join the head table as we start our session, which is going to focus on some very interesting areas of criminal law. Ladies and gentlemen, I know that this is a after lunch session, which a lot of people generally try to avoid, but I think you will be guaranteed that this session will be very interesting and very engaging, because as I said earlier, the speakers we have with us here today have a wealth of experience in matters relating to criminal law. Now, without taking a lot of time, let me briefly explain to you how this session is going to pan out. This session, ladies and gentlemen, will have two segments. The first segment will focus on the issue of bail, and the second segment will focus on bribery and corruption. Now, to share their wealth of experience and knowledge on bail, we have with us here Mr. Anuja Premaratne, President's Counsel, and Additional Solicitor General Haripriya Jayasundara, President's Counsel, with us here. So you see two sides of the bar. The official bar is represented and the unofficial bar is well represented. And I think, madam, you are outnumbered in this group also. But I think we will have a good viewpoint from both sides of the bar.
with regard to bail, we will have the privilege of listening to Ms. Anuja Premaratna, President's Counsel, on making effective bail applications and securing bail in practice. And also on the other hand, we have Madam who will talk to us on the inside the opposition point of view. Why bail is resisted? Because I think we also need to understand the other side of the story. Although many of us will be in the private bar, there is always two sides to every story, and we must sometimes learn to put ourselves in the shoes of our opposite. And also we will try to have a discussion on handling high-profile cases, media pressure, so on and so forth. But I don't want to take any further time from the time of the speakers. Let me now very warmly invite Mr. Anuja Premaratna, President's Counsel, to start his presentation to you on the topic of making effective bail applications and securing bail in practice. Over to you, sir.
Good evening, ladies, gentlemen. Those of whom you don't know me, I'm Anuja Premaratna, and I'm not that tall. So, anyway, let me start by saying, Mrs. Haripriya Sundara can be outnumbered, but she can never be outcast. Numbers will be only a number as far as she is concerned. But the main constraint that I have is, I think all of us have, is that we are limited to 10 minutes, and there's a huge clock looking at us. Right? It's right facing right in our faces. Anyway, let's try to do this as soon as possible. I made a bit of a comprehensive thing, but I don't think I will be able to go through that entirety, or rather I'll try to go through that entirety as soon as possible. Now, when it comes to bail, what is the entire concept of bail in Sri Lanka? If you take the Bail Act, with the Bail Act coming into effect, the whole concept of bail changed in this country. Because earlier, the law was, let's not go back there, 14 days, then if there is no other offense, 14 days, so on and so forth. But now with the Bail Act coming in place, what has happened is that if you go to Section 3 of the Act, right? Now that is one of the most important, that defines where the Bail Act is applicable. So that's the basic overview, where I thought, I will try to address bail under the penal code offences, bail with regard to offences punishable by other statutes, and finally bail pending appeal. So we'll run through this as soon as possible. I'm down to 8 minutes. So if we go to bail under okay, Section 3, if you go to Section 3, what Section 3 basically says that if, other than for the Prevention of Terrorism Act, the Public Security Ordinance, and any other law where a provision for bail is created, that the Bail Act applies. Now, if I may deviate from the original script that I had in mind, now the best example for that was the application made by Mr. Shani Abesekar, on behalf of Mr. Shani Abesekar, the present Director CID. There, the Lordship held, and His Lordship Justice Rohanta Abe Surya appeared for the state. And there, the Lordships of the Court of Appeal held that the Bail Act applies even with regard to offences under the Firearms Ordinance. And bail was granted. So Section 3 defines what is applicable, what is not. Section 2 is that the rule should be to grant bail. And that if it's a bailable offence, basically that we can go to the next slide, please. Then we go to Section 14. Now, whether if the Bail Act applies, the golden rule is Section 2. That is, that it has to be construed that bail should be the rule. Now, the only section that is in the Bail Act that refutes that position is Section 14. So there are 3-4 situations set out that he would not interfere with the witnesses, so that particular gravity of the offence would create public reaction or public disquiet, or that he will not appear at the trial, he or she the accused. Then, in my view, the suspect is almost entitled to bail. If I will try to go through as soon as possible the case law also. So, if we don't fall within this, now my role here today has been to say how to effect a effective bail application. As all of us know, I don't know, it is my practice. When I go to a court, and I see a honorable magistrate before whom I haven't appeared before, I generally ask the practitioners in that court as to how the magistrate thinks. Now, at the end of the day, 2 and 2 is always not 4 in law. Right? What you have to know is who the judge is and how effectively you can convince a judge to get bail for your client. That is, our primary task is this. Because you will see as you go on in your practice, people will spend more on a bail application and less on a appeal when they are convicted. Because by the time they come to the appeal, they are exhausted. So, this is, I'm sure Jayasundra will agree with me, and his Lordship will agree with me. Because we have seen this, when it comes to the appeal, actually the whole family is exhausted and they can't sustain themselves. So, I will not go through these provisions of the law as such, though I came prepared for it, because I can see I have only 3 minutes and 36 seconds left. So, making an effective bail application, in fact, is to first sit down and study your judge and see, okay, is he the kind of person you only address on Section 2 and Section 4? That we will be able to convince the judge. At the end of the day, our task is to convince somebody. So, that task, you have to realize that the person sitting up there is also a human being. I have this saying that I say all the time, I don't know whether this is the proper forum to say this, but let me say this, if it's a male judge, I say it in Sinhala, උදේට ගෑණි බැනලා ඇව්වනම් ඒ ටික ඔක්කොම යන්නේ බේල් වලින් තමයි. But I'm not for a moment trying to look down upon the judiciary or anything, but that person up there is also a human being. He has human feelings. So, I will not go to the special laws and this, that and the other, because my task is not that from what has been given. the main area is to address on the aspect of the bail act. Now, there's also a thing that we all come across with regard to exceptional circumstances. Now, when public property or something like that, then the judge can consider bail only under exceptional circumstances. Now, the law is such that exceptional circumstances does not mean that you have terminal cancer or the accused have terminal cancer. It depends from case to case. It depends from sometimes from court to court, right? It is how you be able to address. Now, if you take a case like this, hang on, this, I always keep forgetting this name. One minute. There's this famous case, Labdi Darage Nishanti CA PHC APN 48 of 2014. It's available on the Court of Appeal website if any one of you all is interested. That takes the Ramuthamurdaram Pille exceptional circumstances to a different level. But Ramuthamurdaram Pille says is also that the exceptional circumstances will depend from case to case, and that you have to address it in those circumstances, and that court also should go with it. And then that is facing at me as 6 seconds. So, exceptional circumstances will depend from case to case. You can go from the lack of evidence at the very inception, whether there is a prima facie case established against the accused or suspect, right? And go on to, and I must stress on this. Now, exceptional circumstances, when we go to exceptional circumstances, there is this important case, Daichani versus Attorney General 2005 2 SLR 152. There, the lordships have, now this is, what is important is, this is a 3-judge bench of the Court of Appeal. So that is going to have effect more than a 2-judge or a 1-judge bench of the Court of Appeal. There they say that the entire policy of the Bail Act has changed after the Bail Act was brought in, the whole concept of bail as far as the whole ambit of bail is concerned, and then that the Bail Act also, the fact that granting bail is the rule should be considered. Now, there is a question and answer session, so I'll hand over to my dear friend, learned and dear friend, is Dasundara, because that has gone blank. Thank you.
Thank you very much, sir. I think there's so much to talk about, but we are on a very tight time schedule. Let me invite Additional Solicitor General Haripriya Jayasundara, President's Counsel, to talk about the other side of this issue of bail. Thank you.
Good afternoon, everyone. Thank you. And Anuja, my good friend Anuja, took the topic very seriously. If not his topic, my topic. Inside the opposition, why bail is resisted, he started fighting with me the moment he sat down there. You know, I actually had to push him and send him away. Now, we are being criticized more often than not when it comes to bail. Shall we look at the popular views? Can somebody do the honor? Okay. What are the popular views? People say when bail is not granted, they say the government doesn't like the suspect, or the political views of the suspect do not align with the ruling party, or say the state council is very rigid, arbitrary and irrational. Short from saying we are mad, they say all those things about us. Investigators are misrepresented facts, and they somehow try to force the accused to either make a confession or plea, or they say the law is too draconian. Remember, whatever we do, these criticisms are there all over at any given time. Denial or grant of bail depends on the, some say denial or grant of bail depends on the skill of the attorney or the temperament of the judge. And my good friend Anuja gave an example. I do not wish to subscribe to that view because there's a woman always. So, myself being one, I don't want to say we do that kind of thing in the morning. So, they say the temperament of the judge and the wealth of the suspect. Yes, that of course play a very, very big role. Otherwise, they won't be retaining any of the counsel who are on this stage. And mind you, Mr. Anuja Premaratna said, by the time it comes to appeal, they're exhausted. Who has milked them? Okay, now let's come to the next one. First, we have to understand the scope and the ambit of the Bail Act, which was introduced in 1997. The first category would be the suspects. The second, those who are accused of being concerned or who have committed an offense. The third category would be the convicted after the trial. So there are now two kinds of bail, if I may use that term. One category of offences would be bailable, but another category would be non-bailable. Now, generally, when it comes to bailable offences, the police can give bail on an written undertaking given by the suspect. But there's an exception under section 6.1 of the proviso of 6.1, where sometimes the police would not give bail on a written undertaking, but would take them to the MC and produce them. The other category is non-bailable offences, which invariably bail will be ordered by the magistrate. Now, Section 14 of the Bail Act plays a very pivotal role because it says when a court can either refuse or cancel bail. I'm not going into much detail about it because it's very much there in the statute. So, but we got to be mindful that there are instances where the court might either refuse or cancel bail. Why I'm stressing upon this is, my good friend started with section 2, which seems to be a very happy place for everyone to be. That is, golden rule is to grant bail, exception is to refuse. But let's see how when we progress, whether it's really the case after this Bail Act was introduced. Section 3 was touched by Anuja, so I'm not going to say much of it in section 3, but I would discuss because it has given exceptions, you know, the PTA or the Public Security Ordinance or special statutes where provisions for bail has been stated, then the Bail Act does not apply. Remember that. Let's look at the thresholds. Because when it comes to bail, don't think people can ask for bail as of right. No, at least I came across one statute which is completely silent on bail. That's the Antiquities Ordinance. Section 15C, mind you, even after the amendment in 1998, says no bail. So that's the law. People, of the misconception, after some time, court has to give. People have to concede. No, that's not the case. There's a statute which says no bail at all. Then there are some other statutes which ask for either exceptional circumstances or which say you have to go to a higher forum. For an example, the Bail Act itself, section 13 says, if it's an offence punishable with death or life imprisonment, then the forum is the High Court. Then the PODD Act, that also has specified two forums. One is the High Court for offences less than 10 grams or substance less than 10 grams. Court of Appeal for substance beyond that. And the ICCPR Act also says it's the High Court. And the PTA, after the new amendment, now the bail either with the High Court or the Court of Appeal. Now let's look at the stages at which we can ask for bail. Now when it comes to a trial, now you all know in terms of section 195A of the Criminal Procedure Code, there is the service of the indictment. So usually with the service of the indictment under 195D, fresh bail has to be ordered by the High Court. So whatever the bail that has been given prior to the service of the indictment, that is for the B report stage. So when an indictment is served, fresh bail has to be given. But there was this judgment, it's very interesting to note that this is Ananda Vikramasinghe Ambepitiya versus, it's there, OIC, who is the OIC? Or the Attorney General actually. So he is one of these VAT case suspects. You all, I don't know whether you all are aware of the case. There was huge amount of money was misappropriated from the VAT fund of the IRD. So he is one of the suspects. In that case, His Lordship Justice Ranjit Silva said, I have quoted that, when it comes to granting of fresh bail, the High Courts can grant fresh bail only if the original bail jurisdiction lied with the High Court or with MC. If the original bail jurisdiction lied with the Court of Appeal, then at the time of service of the indictment, fresh bail can't be granted in terms of 195D. Actually, I'm a little sort of confused as to what can be done. For an example, we'll say it's an offence where the exclusive bail jurisdiction lies with the Court of Appeal. I have only 41 seconds, I'm sorry, I'll just quickly run through. And if the Court of Appeal has granted bail, and if the suspect has, and if the High Court judge has cancelled bail, then the question would arise if bail has to be considered whether the High Court judge has the power to grant bail or whether the accused has to go back to the Court of Appeal and make a fresh application and ask for bail. That question has not come up within a, there is no case law that, although I did a research, we have not come across that situation, so it's very interesting. We have the Honorable President of the Court of Appeal is there, I'm sure one of these days he might be asked to make that decision in one of the cases that would come up before him. And when it comes to High Court, Section 20, just give me 2 minutes, Asela, Bail Act, Section 20 of Bail Act is very much similar to the previous section which we had in the CPC, to 333. So, Her Lordship Justice Shirani Tilakwadana decided In its implementation, that is in the implementation of section 20, the earlier restricted view of the convicted person having to disclose exceptional circumstances for grant of bail must prevail. So, Ramu Thamodaran Pillai case was cited by Mr. Anuja Premaratna. So, remember, so the law, this section 20 is a reproduction more or less of the previous section which we had in the CPC. So, still the exceptional circumstances do matter. And the liberal view that bail should be granted in bailable and non-bailable offences, and the guiding principle is grant of bail to persons before conviction has been curtailed as regards people who have been convicted. So my final note is, remember, judges and state counsel are what? Creatures of the statute. And we are duty bound to carry out the statutory obligations while maintaining independence. Therefore, when the legislature has imposed different yardsticks, nobody can help it. Because we have to follow, neither the courts nor the state can deny it at all, will solely based on the legislative intent which is reflected in the statute. So additionally, state counsel also represent a client, that is the investigative agency. If there is no apparent bias, or if there are no allegations relating to the investigation, then inasmuch as the private bar lawyers are duty bound, we are duty bound to make the application according to the material that has been submitted to us. Because we too have a duty towards our client, here the investigative agencies. So that's all what I have to say, and thank you.
Thank you so much, madam, for sharing your thoughts on the other side of this issue of bail. Why the state would resist, on what basis? I think we need to understand that point of view also. Before we go any further, we have, because of our very limited time, I will only pose one question each from madam and sir for a very brief response. Sir, if you would like to highlight, what are some of the most common mistakes that juniors do in bail applications that you should watch out for?
See, I think there's one thing that we need to get out of. I have seen in several courthouses where not only juniors, all the people get up, most of the people rather, get up and their bail application is, I'll say it the way it is said, so I mean, ළමයි 3 දෙනෙක් ඉන්නවා අම්මට සනීප නැහැ ඒක හින්දා bail දෙන්න. That might work, you know, in a case of having 5 grams a smokable quantity of cannabis or something like that. But when it comes to a proper bail application, what you need to do is to address the law and the facts together. Now, I have seen, over the years, I have seen, you know, the biggest problem that we have when we go to the magistrate's court is that we don't know what is in that B report. So we are unable to address the B report in the first instance. It is if the man gets remanded, then we can have a copy of the B report, then we know what the case against us is. But unfortunately, we get up for the first time. It's a huge problem because we don't know what is in the B report. And more often than not, some is presented to court. In the next day, we go and say, no, this is not the case, this is not that, but that witness has said. So, a proper bail application, what I would say is that you need to know the facts of the case. At least talk to the suspect. If you didn't get the chance of talking to the suspect and he had been arrested, you talk to the next of kin, the wife, maybe the brother, maybe the friend or whoever, and try to get an outline, at least the facts of the case to a certain extent, so that you will be able to address court. And always, I believe that touching section 2 and section 14, And see, section 14, if you read it carefully, it is not that they can, the police can just come and say that the suspects falls under section 14. The words in that section is that there must be material to convince the magistrate that there is a situation under section 14. So that is never done. The last paragraph, if you read majority of the B reports, will say, "Dahatara vagantiye a eka deka tuna a vagantiye yatate remand bandhanakara karana lesa illa sitini." Now, a ekada dekada tunada is never mentioned. So that is in that case, I should admit we start the race slightly behind the investigating officer. But the best way is to get some kind of instructions before you can go into court. And may I please say this mostly to the practitioners in the magistrates' courts. I have seen from the senior most to the junior most, we'll have a half sheet per case, and that folded into 2. Now, if you think that you're bright enough to do a case with a half sheet, God help you, I am not that bright. I still have a file, and in that file I will have all the material that I need. It may be a case you're going to plead guilty, but then still have some material with you so that the judge asks something, you're able to reply. The second thing I'll tell you is never go to court without a file. I have instances where my juniors have told me, "Sir, file le gonna mangi enna." And I say, what nonsense, if the judge asks you something, what are you going to say? I'll give you a classic example in that. Just as we joined the department, my first day in the department, myself and Mr. Harsha Fernando, President's Counsel, we both were in the same batch, if you could remember. And
Can I please interrupt?
Please.
As far as we are concerned, he's a partly heard. He lasted in the department for how long?
Just 1 year.
Just 1 year.
That is because some people take 20 years to learn in the department and then come out.
Let me reply. I think he deserves a round of applause.
So, anyway, so not taking a file, I'll give you the best example what happened. I was called down. We were walking down to have a cup of tea when a very senior officer of the AG's department came and told us, "Yeah, you have just joined the department, no? Here, you take this file, you take this file, and go to the Supreme Court." We went. Now, obviously, this is reality. When you just joined the AG's department first day, you think that you are one above the Attorney General also, or at least you want to feel so. So luckily, Mr. Harsha Fernando's case got called before mine. And he got up and said, "I appear for the Attorney General," and the third, fourth respondents, "Yeah, is that so? We'll take it up for argument." No, Milad, that. And he got a blasting from Justice Mark Fernando. Obviously, we didn't know what it was. And we had, by that time, the department had moved for dates and dates and dates. So, sometime thereafter, my case was called. I got up, I said, "My lord, I joined the Attorney General's department today. I was given this file and I was told to move for a date. I'm here for that limited purpose." So luckily, Harsha's case was called before mine, because otherwise I would have done the same thing that Harsha did and I would have got scolded. So the thing is, at that point, though we had the file, why I am saying you need to have the file is because if there's a question asked from court, you cannot say, "I don't know, my lord," or "I don't know, your honor." Please, the main thing is to be prepared. If you are prepared in criminal law, if you prepare a case, probably there's probably no case. There are some cases, when you're walking in, that your client is anyway going to have. But if you're prepared, there's most of the cases, there's some loophole where you can touch on.
Thank you, sir. I would also like to hear the thoughts of Madam on this issue. You have appeared for the state in countless bail applications. Madam, what are the main or weaknesses or challenges that juniors find that you see from the official bar?
Actually, as Anuja said, preparation is the key. Whether it's for the state or whether it's for the private bar, preparation is a must. Because now, from the point of view of the state, it's not easy to object as such. Because merely because you stand up and say, I appear for the Attorney General and I object to the accused or the suspect being enlarged on bail, nobody is going to buy you. Why should they? So you have to actually state as to why you are objecting to bail. And it has to be reasonable, within law, and it has to be very convincing. Unless you have got a very good set of observations from the investigating authorities, with prior convictions or pending cases or similar offenses that are being investigated even at that time, it's not proper to object for the mere, for the sake of doing it. So you have to take the gravity of the offense into consideration and the antecedents and all the other material. You have to take a holistic picture. So only then one can actually make a proper application before court objecting to bail. So preparation is the key, and the support that you get from the investigating authorities is another factor that really helps you to make an effective submission before court.
Thank you, Madam. Before
May I also add one more thing? When you are appearing for a client, especially in the bail application, please allow the police or the Attorney General's Department representative, whoever, to first say their part. Because once you look down and wait till that application is made. If we jump the gun, it's very difficult. Then, but the actual thing is they should first move for remand for us to move for bail. So, if we listen to them rather than jump in the gun, we can find a lot of loopholes in their own submission. That helps you a great deal in addressing it. And more often than not, they will make half an hour submission, not touching on the bail act or section 14 or whatever. So you can just get up in court and say, my learned friend or police niladari was talking for 15 minutes. Did he say a word about the bail act? So that is also something that you must keep in mind.
Thank you very much, sir. Before we move on to the next segment of our session, just a final comment from both sir and madam on this issue of handling so-called high-profile cases. I don't know whether there are actually cases called high-profile cases, but so-called cases which are sensationalized in the media. Just a thought from you, Mr. Anuja Premaratne, President's Counsel. How do you see this, and how do you conduct yourself in this age of media and social media and all of that?
The best is to stay away from the media. Have anyone of you ever seen me talking to the press? No, I never. Because the moment you talk to the press, they will edit and put it the way they want. And I'll give you a classic example of both Mr. Jayasundara Harip, my good friend Haripriya, and his Lordship Justice Rohantabe Surya. Justice Rohantabe Surya and I myself, I was for the defense, he was for the prosecution in one of the most high-profile cases, so to say high-profile cases, in the killing of Ravi Raj. And that was given press coverage almost live. Neither did his Lordship address the press, nor did I. If the press was on this side of the High Court, we used to go out from the other side of the High Court. So we never had any kind of pressure. Similarly, I was long years ago, I was junior to Mr. Dayapera. Mrs. Jayasundara was junior to His Lordship Justice Jayanta Jayasuriya when we did the Royal Park murder, right? Now that was not only in the Sri Lankan media, that was all over the foreign media. But none of us ever, we walked out of the court and went. If all that they could do was videos coming into court and going out of court. Nothing more than that. So the whole problem is, some of our lawyers think that going and talking to the press will be, I don't know what it is, whether they might be thinking that they become popular or whatever. And I can tell you frankly that to my knowledge, it doesn't happen, right? But keep that aside. Keep aside your being able to handle the press. Is it right for a lawyer to make a submission to court and make that same submission to some, excuse my language, petty press officer or a journalist? We have addressed court, surely. Right? And then you go and say, Mama Mema Kyu, I told this, and the judge helped with me, or otherwise. So I don't know how ethical that is for that matter.
Madam, your thoughts also on that?
Yes. Actually, I really do not know what these high-profile cases are. To me, every case is the same. I'm not onto Facebook, not on Instagram, nor into social media. So I would not know what people talk about me. When I take over a case, the first thing that I tell my husband is, don't come, after reading all these things, don't come home and ask me. If you want to confront on anything, please do ask me. I do not know as to what this media people are talking about me when I take over a case. So actually the first thing, y'all are very young, first thing that y'all should take to heart is, we are professionals. We have to conduct ourselves as professionals. Remember, we can, go and shout and put our fist in the air and say certain things, and those are captured and videos are taken. Those will be there forever. Do you want to see your young self in another 25 years' time like that? So best thing is, act professionally. For me, when I get a case, I don't know what pressure is because I don't care. Because when I get a brief, I look at the facts within the four corners of the brief. If I can justify legally and also my conscience, yes, I do undertake and make submissions accordingly. Not for the press, not for the gallery, only to be heard by the learned judge and by the learned counsel who may or may not agree with me. At the end of the day, even if I'm, after giving me a, hearing, very patient hearing, whatever the order that comes my way, I'm willing to accept. Because I know that I have done my duty by the client or by the brief or the facts that have been presented to me. The rest is immaterial to me. After all, the person who makes the decision is also a human being. And Anuja, mind you, started saying as to how they were treated in the morning by their own wives do matter to them when they take decisions. It doesn't apply to my good friend, His Lordship. So that's it. So what we have to do is to be and act like a professional and make our submissions accordingly. Forget about the societal pressure or the peer pressure or the media frenzy. It's not going to take you anywhere. Because at the end of the day, they are going to make a story out of it no matter what. So best thing is to be a professional and act like a professional and do your job professionally. That's all what I have to say.
Thank you very much, madam. I think those thoughts coming from such senior eminent members of the bar will surely point you towards the right direction. And without taking any further time, let's go into our second segment of this session, which is focusing on bribery and corruption. I don't think I have to make any introduction on this. We have with us here today Senior Attorney at Law, Mr. Ashoka Veerasurya, who will speak to us on the legal framework relating to bribery and anti-corruption. I will not take any further time and leave the floor to you, sir.
Good afternoon to everybody. Unfortunately, I have been asked to give a lecture on the legal framework relating to bribery and anti-corruption. The problem is, had the organizers asked me to discuss about the practical aspect as to the applicability of this act, I would have been very happy, like my friend Sanuja Premaratna explained to you. However, in fact, I asked Mr. Tisse Veeragoda also, why did you ask me to do this, as I am not academic anyway. Probably he has done the job and now he is waiting, laughing and waiting, I can see that. So, coming back to this issue, before coming here, I thought I can take some time, at least 30-35 minutes, and came ready with 14 slides. Now I realize, having come here, I don't know whether I can at least take 2 or 3 slides. Anyway, without wasting time, let me start by saying, now this new act, that is act introduced in 2023, is the latest act, as you know, Act number 9 of 2023, which has repealed 3 acts. One came in 1954, thereafter in 1975, which discuss about assets and liabilities, and also the famous Act number 19 of 94. We call it SIABA. Now anyway, these things are now over. I would appreciate if you can put the first slide and just glance through. Okay. And then go to the next slide. Now, then we have the okay. Now slide number 2. Slide number 2 I don't think has any importance to you people, and we don't have time. And then the purposes of this act might be little important. You see, now we know the purposes of this act is to make sure that we have an independent commission placed in Sri Lanka and to go ahead with this. You see, now the composition is next one is the composition of the act. I don't think I am going to discuss anything on that. All of you know. All what I want to say is the Chief Executive Officer of the Commission is the Director General, who is in charge of manning the Commission plus the finances. And other things you, of course, you know. Then we have slide number 6 here, powers and functions of the Commission. That also I don't think we have time to go into. And the slide number 7 might be slightly important, because that will, make sure how to make a complaint, whether orally or writing or in electronic communication and stuff. And also how they could act. Now, actually, this commission may act on its own, ex mero motu. That means initiating things on their own. And all what they do is they can do a preliminary investigation, and there is material. The commission will tell Director General to go ahead. And then what happens is, then comes to the investigative powers of the commission. they have absolute powers, I must say, with starting from section 47. They can arrest anyone and they can detain anyone for 24 hours. They can, search any premises, seize documents or properties, and they can in fact take non-intimate forensic samples. Forensic samples such as fingerprints, handwriting, samples and hair. Then they can do freezing of accounts. This is a very important thing. Freezing of property, all what they have to do is under section 53, they have to immediately go before High Court and give reasons, and they can go up to 1 year. If an indictment is filed, they can go up until the trial is over, in fact. And basically, they don't need any kind of, even the law says under section 52, the commission can always get the assistance of a magistrate. I don't think they need any powers of any magistrate, because they have absolute powers, independent powers. And in fact, I forgot to tell you this. Now, this act was operative from August 2023. So that means this act was brought in by the previous government, I must tell you. This is not to discuss about politics. And this present commission they are very active. They are very focused as to what they want to do. And they are going ahead with this. And the problem is, people are unnecessarily trying to be critical of this, since they don't know what the powers they have, they don't know what they can do, and as a result, we are yet to see what is going to happen. So, then in addition to the powers I discussed a little while ago about the investigative powers, then what they can do is, they can always forward papers, charge sheet to the magistrate. Indictments can be forwarded to the High Court without AG's interference. And also, if they are not satisfied with any of the orders, always DG can file an appeal, as much as you and I can file an appeal. And the important thing is, if we are aggrieved by any orders, we have to go to the Supreme Court. Nowhere else we can get orders on this. So there is no way in which this process can be stalled or delayed. So that is also a good thing, I think. So, I mean, unless somebody can go to Supreme Court and satisfy, they have a reasonable grouse, they have a reasonable case, I don't think anyone can stall the process of the bribery commission. Then we have this very important thing with assets and liabilities. I think I have passed that. Assets and as a declaration assets. Now, actually, declarations assets came into force by Act number 1 of 1975. Now, when we were State Council, we used to give the assets declaration to the head of the department, not to the Attorney General, of course, to the administration. I don't think anyone took serious. Now, as this law stands, all the declarations has to be communicated to the Bribery Commission, and they are on the verge of forming a digital system, like a central authority on this. So I read an article, by 26 March, that is for the next financial year, all the details, starting from judicial officers to all the public servants, assets and liabilities will be online. And there will be a lot of interesting things will happen. I am sure all of you will have a lot of work and a lot of litigation will come thereafter, because as you know, now I can go a small example, practical example. If you don't pay income tax, when you declare assets, for the last 5 years, one can challenge and ask the IRE to take income tax. But if you have undeclared wealth and suddenly these things comes out, there will be people who will be complaining to the Bribery Commission with the assets. And there's going to be huge problem. And if they don't take action, there will be huge issues. So interesting things should come in time to come, not immediately. So basically, this the declaration of assets and liabilities is a very important area. Then we have, these are another very important thing for all of us practicing lawyers. I have described everything here under the offences and penalties. I can't go one by one. Everything is here basically. And the most important thing is, if you make a false complaint under section 119, that person can be, the commission will take action against him. And there are whistleblowers, that means people who are helping the commission, and they are also protected. And a lot of laws are there to protect them. So that's another important thing. And then with these offences and penalties, sports corruption has come into place, illicit enrichment, and then of course corruption is there, as you know, the sentencing is very hefty. And then even the private sector bribery is another interesting area to come. We have to see how this is going to develop. That means the corporate sector is also liable. So they can't be out of it saying all public servants are involved in it. All of us are involved. So keep that in mind. Just because we are lawyers, I don't think we can be, we'll also will be liable if we don't do this properly. That's a very important thing. So now, then I'll come back to the bail. I think all of us are keen to know what bail is. You see, bail is now all these offences are cognizable offences, non-bailable that means. So now, in a raid case, if a person is taken into custody on a raid, always the DG will file a certificate. Then what happens is, unless exceptional circumstances are adduced, no magistrate can give bail. So as you know, that's a simple law. But now I saw in the recent past, there was somebody taken into custody on a charge of corruption. The charge was coupled with public property. So that accused had a huge problem and he had to be in remand for a long time. I don't know, Mr. Premarath appeared, I can't remember. I don't want to mention names, I'll tell Mr. Premarath separately. But that's an interesting twist in the law. I mean, you see, the commission is very smart to do that, because now person is charged on a charge of corruption and that is coupled with public property. Very smart, I would think. I mean, I don't think that means that shows how powerful this act is, how good this act is, I must tell you, even though we are in the private bar. Now coming back to this issue, the bail, detention, you can keep somebody for 24 hours. You don't need anyone's permission. You can question anyone and keep anyone for 24 hours. So now I'll take few more minutes and tell this, something very important. This piece of legislature is not only about taking people into arresting people or doing investigation. They have much more actually. They will have a national plan very soon as to how to educate people, as to how to make sure from school level upwards how a reasonable citizen should behave in a country like this. How this should be done. In fact, this piece of legislature will be important more than for me, for you all, for future generations. And remember this, some of you might think, this bribery act, corruption act is useless thing. I'm going to do civil work, I'm going to do commercial work, I'll be only concentrating on the writs and Supreme Court and so on and so forth before Lordship Abhay Surya. But remember this act is a futuristic act. All of us needs this act. This act will be the future of this country. And remember this act will be the future, and also for future generation, ladies and gentlemen, this will be the turning point of our country actually. And if things fall into proper place, I'm sure we can have a better Sri Lanka. I must tell you that. That is even though I'm in the private bar, that is my wish also. Because this corruption should be eradicated in some way. At least try to minimize this. We can't go on like this. So I'm very happy that this very good piece of legislation has brought in. In fact, the people who are criticizing about this act, I want to tell you something for you to know. There might be people who are doing politics here. Do you know that the 19th Amendment was brought in as far back as 2015? 2015. When 19th Amendment was brought in, it was decided to have an independent consul. independent commission. So that means 15 years ago, the Constitution of Sri Lanka, as per the 19th Amendment, decided we are going to have an independent commission. So at least after 10 years, now we have got a commission. So we must be happy about it. So I don't think I can go on any more about it. I have so many things to tell. I came ready to tell also, but I don't think we can tell. Probably during the question and answer hours, we might be able to discuss a little more about it. Thank you very much. Thank you.
Thank you very much, sir. I think we don't have enough time to go through all of what you said, but you were able to summarize and generate that interest in the audience about this Anti-Corruption Act. And I think sir's presentation will also be, I think it has been circulated amongst the audience. It will be circulated, so that will be of great value to you. Next, let me invite Mr. Anil Samarasuri, attorney at law, who's going to talk to us on another very interesting aspect of this Anti-Corruption Act, which is bribery and corruption in both the private and public sector in the current political climate. As sir previously pointed out, bribery and corruption is not only confined to the public sector. So let me invite Mr. Anil Samarasuri to share his thoughts on this topic.
Thank you, Asela. Good evening to you all. Unlike the other speakers, I have got a topic which is more suited to a politician, I would say, but at the same time I'm conscious of the fact that there is a contempt provisions that have been incorporated into the Act, so I'll be very careful in what I comment today. Be that as it may, we all know, and we have always observed, and we have experienced this, that is, close upon elections, we always observe that one of the main and significant slogans of the opposition would be the alleged corruptions of the government or the ruling party. And if they happen to succeed during the elections, then you will see, once they establish their regime, there will be many actions that have been instituted, mainly relating to alleged corrupt practices of the previous regime. Now, this will add a lot of burden to the judiciary and the prosecution, but of course, this is an opportunity for us. This is a golden opportunity for us. The politicians will come and go, but because of their acts and previous and the present acts, gives us an opportunity. So that's something that we will have to grab with both hands and make the most out of it. Now, having said that, I believe every one of you all will, without any reservation, accept the fact that bribery and corruption needs to be prevented and eradicated. Because prevention and eradication of bribery and corruption is a must for a smooth functioning of a democratic society and for good governance. If not for, as Mr. Ashok Vidusuriya stressed, whichever side we are, I don't think any one of us can condone bribery and corruption, because that will be the one factor to ruin a government and a country, and at the end it will be the people who will suffer. So bribery and corruption needs to be eradicated and prevented, and now we have an act to deal with this issue. Bribery and corruption has become a significant problem and issue, particularly in the government sector or the public sector, and it is spoken a lot. And what are the factors that pave the way for bribery and corruption in the government sector. In my opinion, it's the weak governance, weak implementation of the law. The laws are there, but having the law is one, but if that is not implemented, then it's absolutely almost good as not having the law. Then the accountability. The conscience of the people to do what you have been assigned to do without seeking for any gratification from the people that come to you for the job that you're supposed to do for them. Then political, over and above all these, particularly in the public sector, the political interferences or the influences happens to be one of the main factors that has created the bribery and corruption. There were no controls, there were no checks and balances with regard to the certain actions of certain public officers, and that has led to a serious deterioration of the public sector and their function. Now, we always a lot speak about the corruption in the public sector. We speak little about the corruption in the private sector. Who contributes? If you take a country as a whole, corruption as a whole affects the country, affects everybody. One cannot categorize corruption just to one sector and look at laws to eradicate corruption in that particular sector. No, corruption as a whole has to be prevented, eradicated from the society for good governance, for a smooth flow of democratic society. Now, this is an act that was introduced in 2023, Act number 9 of 2003, taking into consideration the widespread corruption that is there across our society. They have identified that there is corruption in the public sector as well as in the private sector. The corruption in the private sector was ignored to a great extent in the previous legislation. Now, that has been dealt with in this act. As Mr. Virasi said, we have an act which is a very strong act that stands very strongly to eradicate, prevent corruption. And this act also has established a commission, an independent commission with absolute power. If one looks at section 2, which was reported in one of the slides of Mr. Virasuriya, you will see the objectives of the commission. Objective of the commission is not confined to eradicating and preventing corruption. It also deals with, or it meant to deal with, educating the public, educating the citizen of this country with regard to the corrupt practices that are being practiced and how those things should be dealt with. And this act from section 32 to 72, chapter 4, if I remember right, provides wide range of provisions giving absolute power to the commission to inquire, investigate into complaints that they receive. And they have so much of power to deal with the people who are responsible for such acts in a very, very serious and a strict way. Apart from dealing with them, they also have provisions which protects the people who are associated with the complaints that are made. And the penal provisions, as he explained, does not confine to a mere sentence or a fine. It deals with the assets that they have acquired through illegal means. So, we have an act introduced by the previous government, which gives wide powers to an independent commission. An independent commission was a must, was a need of the hour to fight against corruption. And also, they needed provisions to safeguard the people who are associated with complaints made to the commission. So now you have an act. So the stage is now being set up by introducing 9 of 2023. By a gazette notification, it was brought into operation. So whatever the government it may be, whoever is going to be in charge of the government, who will be running the government, has a perfect tool, has a perfect mechanism. And we have heard that the government intends to establish, need about 4 courthouses that would deal with bribery and corruption for the purpose of expediting the trials. Because it's pointless having a law and trying to implement it if the trials are going to take long time and if people are not going to feel, particularly the people affected and the people responsible are not feeling the implementation of that. So now, in very soon, the courts will be specially established to deal with matters arising out of this act. The tools are there, and if one looks at the current political scenario, I will very briefly say this. We have a government, we have a party that has come into power, who has been in the opposition right throughout, and they have been agitating about the corruption, bribery and corruption of the previous government. So they have a wonderful stage to implement and do or put into practice what they have been preaching up to now. The stage is set. Now it's up to the people responsible to deal with it, implement the law, and see that the objectives of the Bribery Anti-Corruption Act is achieved soon, so that there will be a better future for everyone, for our future as well as for us. So I will stop at that, and thank you.
Thank you very much, Mr. Anil Samarasuriya. We have been given strict instructions to stop this session by a particular time, but I can't resist the temptation of giving Mr. Asoka Veerasuriya and Mr. Anil Samarasuriya the opportunity of just addressing some 2 very small issues, sir. So now, in order to make your presentation, we had the old Bribery Act and the old CBOC law. But now we have the Anti-Corruption Act, which is an entirely new legislation. We saw the presentation that's made. As a young lawyer, you must have wondered how, sir, analyze this law. So I just wanted to ask you, sir, when a new legislation of this nature, something very voluminous, comes your way, as a young lawyer, how do you get into studying a law like this, and what is your advice that you can give to our audience on that? Yes, as a senior lawyer to our young members of the bar.
Thank you. Now, that's a difficult, tricky question to answer also. Now, having said that, now we are usually, as seniors, we are used to the normal bribery cases, corruption cases in the magistrate's court, and assets cases. Now, those are actually, we are used to it as to what approach we must take. But now with this new act, which is, I think, this is a holistic act. I mean, it covers all the aspects of it with extreme power. So I think the first thing a lawyer must understand is you must try to understand the scope of this act. That is very important. First is the scope of the act. You must, now for example, now if you, now there are, if you, now for example, I'll give a small example here. In my note, if you look at my note, I have categorized offences starting from section 93 to 117. You see now, those are very important areas as a lawyer you should study and see as a practicing lawyer. Then of course, what is important for us is bail. It's a lucrative area of practice as for lawyers. And that also you must look at it. These are cognizable offences. You must try to understand the law as it is. And also with regard to the assets, those are the three areas I think as lawyers we have to understand, and we have to look into it very carefully. Having said that, now little while ago, Mr. Anuja Premarath also asked me this question and we were just talking about it. Now the question all of you and all of us are going to face is this. When a person goes to the bribery commission, they not only take a statement, they try to justify it by way of an affidavit. So I don't know, we are yet to see how to overcome this. So I don't know how to advise a junior or a senior on that part of it. So this is a brand new law. We have to see how and what to do is a thing. We have to look at. We have to probably, I don't know, we have to assume certain things, and we have to see how the court is going to act. We are yet to see the decisions of courts coming up in the magistrates court or high court. So let's see. As the order, as the judgments comes up, only we have to see. We have to think of how to approach this. I don't see a way out. I don't see a direct way out in this special statute.
Asal, if I'm to add something to what Mr. Vidusi said, now we have a new act that has come in. Now this act has repealed certain acts. I believe for one to understand how this operates, of course one need to go through each and every section. There is no alternative to that. But in order to understand this act better, not only this, any other act which has come in by repealing some old laws, to understand this better, it is always better that you go through the acts that have been repealed, the history. Then you know how it has evolved to the present position. So that will give you a better understanding. It's not just the understanding of by reading, but by looking at the history, you will get a better understanding of what it really means. That understanding is very important because as Mr. Premratna very correctly said, they will be looking at certain new areas to be covered. So then okay, right, these were not there in the previous act. Now, for example, the corruption in the private sector was never in any of the acts. But now it has been introduced. Why is that? So likewise, you will, once you start reading the repeal laws, you will start questioning yourself as to why these provisions have been brought in, and that will give you a better understanding of the law.
Thank you very much, Mr. Samarasuriya. I think in keeping with the session schedule of the organizers, it has been a very engaging and interesting session, and I have been privileged to have been involved in this session with Additional Solicitor General Ms. Hari Prajayasundara, President's Counsel, Mr. Anuja Premarath, President's Counsel, Mr. Asoka Veerasuriya, Senior Attorney at Law, and Mr. Anu Samarasuriya. It has indeed been a real pleasure for me and a privilege, and I think you in the audience would have gained a lot of perspective and knowledge from this session. Let me finally thank each and every member of the panel and all of you who have attended this session, and also the organizers for organizing this session. And I think we have been unable to give you an opportunity to raise questions because there is going to be a break and another session to start thereafter. So, although there is plenty to talk about with this lady and gentlemen, we will have to wind up today's session. And thank you very much, and I hope you have a very pleasant evening. Thank you.
On behalf of the participants and the committee, I would like to thank the panelists for their contributions and for giving us insights into their own experiences from the Bail Act and the Anti-Corruption Act. Dear sirs and madam, we thank you very much once again for all the participants for sharing your knowledge. And as a token of appreciation, I would like to invite the chairman of the Junior Bar Committee, Mr. Tishya Beregoda, and the head of sessions of the Junior National Law Conference, Mr. Gamindu Karunasena, to award the small tokens of appreciation.
Also, if there are any other questions, you are free to speak to any of the panelists. They are very great. they are open to any questions now onwards. Yes, yes. They are always very approachable.
Everyone, special announcement once again. We are going to follow this session with the session on criminal justice, plea bargaining, from the origins and the legal framework to strategic planning and practical realities, which will be following up after this, right after this session. So please stay tuned for that as well. Thank you.
Everyone, one small announcement. For the gala night at 8 p.m. today, you all need to bring your wristbands to attend. I repeat, it's very important that you all have your wristbands in place with you all when you all attend the gala dinner at 8 o'clock today. If you all don't have your wristbands with you all, please speak to a committee member to get one. We will help you. Thank you.
in Sri Lanka explores one of the most significant recent developments in our criminal justice landscape. As Sri Lanka moves forward, adopting more efficient, victim-sensitive and pragmatic mechanisms for resolving criminal cases, plea bargaining presents new opportunities along with important questions about fairness, transparency and access to justice. This discussion will help us better understand its potential importance and impact on court congestion, prosecution strategy, and the rights of the accused. It's my pleasure to introduce our moderator for the session, Mr. Darshana Kuruppu, attorney at law. Mr. Darshana Kuruppu, attorney at law, is a seasoned criminal defense attorney with nearly 18 years of experience in practice, renowned for his expertise in complex criminal litigation. He holds a Bachelor of Laws degree from University of Colombo and a master's degree in law, graduating at the top of his batch with a distinction. Beyond his extensive practice, which spans to serious criminal matters, cases involving scientific and technical evidence, fundamental rights applications, and appellate advocacy, he also serves as a visiting lecturer in criminal law at the Open University of Sri Lanka. A formidable advocate, educator, and mentor, Mr. Kuruppu continues to contribute significantly to the legal provision and the advancement of the criminal justice in Sri Lanka. May I please invite you, sir, to commence this session.
Ivan, good afternoon, Your Lordships, President's Council, respected members of the judiciary, learned members of the bar, distinguished invitees, and ladies and gentlemen. It is truly an honor and a privilege to welcome you all to this discussion, plea bargaining furthering the criminal justice system in Sri Lanka. We gather today at a very significant moment in our legal history, one that marks not just a procedural reform, but a meaningful shift how justice is understood, applied and experienced in our courts. As we take steps toward introducing plea bargaining into our legal system, it is important that we come together to reflect on its role, its promise, and the practical realities of its application in Sri Lanka. To guide us through this conversation, we have privilege to have with us three eminent speakers. Let me introduce, firstly, His Lordship Justice Jasantha Kodagada, President's Counsel. His Lordship Justice Jasantha Kodagada, President's Counsel, is a sitting judge of the Supreme Court with a distinguished career in public service, appellate advocacy and criminal justice spanning over 3 decades. Called to the bar in 1988 after his primary legal education at Sri Lanka Law College, he joined the Attorney General's Department in 1989 and rose through its rank as a senior state counsel, Deputy Solicitor General and Additional Solicitor General before being appointed as a President's Counsel in 2015. In March 2019, he was appointed as the President of the Court of Appeal, heading its administration and jurisdiction, and in February 2020, he was elevated to the Supreme Court. He holds a LLM in Public International Law from University College London and a postgraduate diploma in Forensic Medicine and Sciences, and is widely recognized as an authority on complex criminal prosecutions, human rights, national security law, proceeds of crime, victim and witness protection, and medical legal practice. Justice Kodagada has led and advised on landmark prosecutions, multi-jurisdictional investigation, UN and Commonwealth engagement, key law reform initiatives and high-level commissions of inquiry while serving for many years as a lecturer, trainer and a leader in criminal law and public law. Throughout his career, Justice Kodagoda has demonstrated an unwavering commitment to uphold the integrity of judicial processes, the independence of the judiciary, and the pursuit of justice through fairness, balance, and accountability. I respectfully invite His Lordship Justice Jasantha Kodagoda, President's Counsel, to kindly take his seat for the session. Secondly, His Lordship Justice Rohantha Abesurya, President's Counsel. His Lordship is the President of the Court of Appeal and a distinguished jurist with over 3 decades of service and public prosecution and legal administration, a graduate of the Faculty of Law, University of Colombo, and holder of a diploma in international affairs and professional diplomacy from Bandaranayake Center for International Studies. His Lordship was appointed as a President's Counsel in 2019 in recognition of his excellence and integrity. Before his elevation to the bench, His Lordship served as the Senior Additional Solicitor General and the head of the Criminal Division of the Attorney General's Department, where he supervised high-profile investigations involving terrorism, corruption, trafficking, and financial crimes. He also has prosecuted some high-profile cases. His Lordship has represented Sri Lanka at Global Legal Forum convened by the United Nations, Interpol, and the Council of Europe, and continues to contribute actively to law reform and institutional integrity in the justice system. Finally, we have with us Mr. Salia Piris, President's Counsel. Mr. Salia Piris, President's Counsel, served as the President of the Bar Association of Sri Lanka from March 2021 to March 2023 and was named Sri Lankan of the Year by LMD magazine in December 2022. He began his legal career as a prosecutor in the Attorney General's Department. Between October 2015 and March 2018, he was a member of the Human Rights Commission of Sri Lanka, and from February 2018 to September 2020, he served as the first chairman of the Office on Missing Persons, a key institution in Sri Lanka's reconciliation process. Mr. Piris holds a master's degree in international business law from the University of London and a bachelor's degree in law from Open University. I respectfully invite these 3 eminent speakers to the stage. These 3 eminent speakers will engage in a moderated panel discussion followed by a Q&A session after delivering their speech. Let me first introduce today's topic. Ladies and gentlemen, for many years, plea bargaining in Sri Lanka existed in something of a grey area, informally practiced in the magistrates' court and high courts, but without clear statutory framework. Now that has been changed with the enactment of the Code of Criminal Procedure Amendment Act number 50 of 2024. Sri Lanka has formally introduced plea bargaining into its criminal justice system. For the first time, our law recognizes process where an accused person can enter into an agreement with the prosecution, pleading guilty in exchange for certain concessions, such as a reduced sentence or lighter fine or the withdrawal or drop of certain charges. Ministry of Justice has stated this reform primarily aims to reduce the mounting backlog of cases pending all over the country and minimizing prisons overcrowding while maintaining fairness and transparency. But more importantly, this amendment represents a shift in how justice is administered. It moves us from a strictly adversarial process towards a more negotiated and restorative approach. Ladies and gentlemen, the new provisions attempt to address these concerns through judicial oversight. The court must be satisfied that the plea is voluntary, that the accused is represented by counsel, and the right to a fair trial and appeal are properly explained. The judge retains discretion over sentencing, which safeguards the authority of the court. A special progressive element is the recognition given to the victim. Victims also have a voice in terms of this new amendment. At present, over 1.1 million cases are pending before our courts. Many of them involve very minor non-violent offences where lengthy trials serve. The accused know the public interest. If we implement this new amendment, I think we can save our valuable time. So, for the interest of time, without discussing about the history of plea bargaining, I would like to invite Justice Rohantha Besurya, President's Counsel, to address the gathering. Today, His Lordship will speak on plea bargaining in Sri Lanka, reasons, origins, existing legal framework, and proposed development. Over to you, sir.
Thank you very much, Mr. Darshana Kuruppu. Good evening, ladies and gentlemen. Since we are severely constrained for time, I am going to do something which I hate to do. I hate to read from prepared texts or prepared speeches, but I'm compelled to do it this evening in order to conserve time. But before I do that, Mr. Kuruppu, please give me additional 1 minute to respond to certain comments which were made by the members of the previous panel. His Lordship Justice Kodagoda was not here, I think, when reference was made to the spouses of judges, and the impression created is that most judges quarrel with their wives and then send the bench in the morning, and then the poor litigants have to suffer because of those quarrels. I wish to assure this audience that that is not the case. I know for a fact that His Lordship Justice Kodagoda's and household and my household, we don't get quarrels like that, and we don't allow our personal issues to affect our work. Then secondly, in the previous session, there was repeated reference made to several laws in the country, the Seabok law, the Act, the anti-corruption law, the bribery law, and so on and so forth. I wish to add another landmark piece of legislation to that list, which was enacted very recently. And why I'm referring to that law is simply because the architect of that law, which is a landmark piece of legislation enacted by the Parliament of this country unanimously, not one member of Parliament voted against, not one abstained, unanimously. The architect is none other than His Lordship Justice Yasantha Kodagoda. And we are very proud of the fact that we were also part of the committee which drafted that law. That is the Proceeds of Crimes Act, which is now in force. So we are extremely privileged to share the podium with His Lordship Justice Kodagoda. Plea bargaining is a negotiated agreement in a criminal case between the prosecution and the accused, where the accused agree to plead guilty to a charge, usually with the expectation of receiving a concession. That concession might take the form of a reduction in the charge, a lighter sentence, or even the withdrawal of certain charges. However, and most importantly, such an agreement is not effective on its own. It must be placed before court, and the judge must be satisfied. Firstly, the plea is voluntary. Secondly, the accused understands the implications of pleading guilty. And thirdly, there is a factual basis for the guilt admitted. In simpler terms, one may say that plea bargaining enables the accused to accept guilt earlier and receive some form of benefit, thereby avoiding the length, cost, and uncertainty of a full trial. Why do countries adopt plea bargaining? The reasons are both practical and theoretical. Firstly, plea bargaining reduces delays, as was referred to by Mr. Darshana Kuruppu. Many judicial systems struggle with heavy case backlogs, and Sri Lanka is no exception. Trials involving multiple witnesses and complex facts are time-consuming. Plea bargaining allows certain cases to be resolved more efficiently, freeing the judicial system to focus on more serious or contested matters. Secondly, it reduces costs. Long trials require time, court resources, legal personnel, and sometimes expert testimony. A negotiated plea reduces the financial burden on both the state and the accused. Thirdly, plea bargaining benefits the victims. Rather than waiting years for the conclusion of a trial, victims may receive faster closure and, in some cases, quicker restitution. Fourthly, prosecutors gain greater certainty. A plea agreement provides a definite conviction rather than risking an acquittal at trial due to evidentiary difficulties, witness unavailability, or procedural complications. Finally, plea bargaining may help reduce overcrowding in prisons, particularly in situations where individuals are detained on remand for extended periods awaiting trial. While negotiated pleas have existed in various forms for centuries, modern structured plea bargaining developed most prominently in the United States during the 19th and 20th centuries. Over time, many other jurisdictions, both common law and civil law, adopted versions of this system in response to similar pressures of caseloads, cost, and efficiency. However, the degree to which plea bargaining is regulated differs from country to country. Some jurisdictions allow extensive sentence negotiations, while others limit negotiations strictly to lesser charges or agreed facts. The international trend has been to formalize and supervise the process to prevent potential abuses. For many decades, Sri Lanka did not have an explicit codified system of plea bargaining. Nevertheless, in practice, certain forms of informal negotiated pleas did occur. For example, in some cases, the prosecution and the defense would agree that the accused would plead guilty to a lesser or alternative charge, and the court would record such a plea. However, such practices lack a clear statutory structure, leading to uncertainties regarding fairness, procedure, and judicial discretion. A significant leap forward took place with the enactment of Code of Criminal Procedure Amendment Act number 2 of 2022, which introduced the pre-trial conference mechanism under section 195A of the Criminal Procedure Code. This allows the High Court to conduct structured discussions before trial to identify contested issues, narrow down legal issues, and encourage early resolution where appropriate. Although these provisions does not itself create plea bargaining, it facilitates early negotiations and case management, laying the foundation for a more formal plea bargaining system. In recent years, Sri Lanka has recognized the need to address severe court backlogs and long delays, particularly in criminal matters. In response, amendments to the Code of Criminal Procedure were enacted with the express purpose of establishing a formal plea bargaining framework. Towards this end, Code of Criminal Procedure Amendment Act number 50 of 2024 was passed by Parliament and certified by the Speaker on the 14th of September 2024. The key features of the Amendment Act may be summarized as follows. Number 1, written plea agreements. All negotiated pleas must be documented in writing rather than arranged informally. 2, judicial oversight. The court must question the accused to ensure that the plea is voluntary, informed, and based on facts. 3, legal representation. If the accused does not have a lawyer, the court may assign one to ensure that the accused understands the legal implications before entering the plea. 4, standard procedure. A formal procedure and format for plea agreements have been provided, reducing inconsistency between various courts. In that particular enactment, this particular format is described as Form 23, which is in the schedule. There's a particular format in which the plea agreement must be entered. 5, limits and safeguards. The court retains the discretion to reject any plea agreement, possibly on justifiable grounds, such as it being unjust, coercive, or contrary to public interest. This is evinced from Section 3 and 6 of the aforesaid CPC amendment, which introduced new provisions by way of Sections 183A, subsection 14 and 197A, subsection 14 to the Criminal Procedure Code. As per the Act number 50 of 2024, any party may initiate the offer to enter into a plea agreement. It may be the accused, it may be the prosecution. However, the prosecution shall maintain the sole discretion on whether or not to enter into a plea agreement with the accused. One of the most salutary provisions contained in the said Act is the reasonable opportunity offered to a victim, either directly or through counsel, to make a written representation to the prosecution regarding the impact of the crime. It should be borne in mind the fact that notwithstanding the recommendations of the parties, the court shall retain the sole discretion on sentencing and the discretion to indicate the sentence that may be imposed. When the court accepts the plea agreement, it shall become binding and appeal shall not lie. No appeal shall not lie from a conviction imposed after the court has accepted the plea agreement and the sentence imposed consequently. It appears that the courts cannot arbitrarily reject plea agreements since the said enactment requires the court to record reasons for such rejection. It also stipulates that no appeal or revision shall lie against such rejection. These developments signals a clear policy direction Sri Lanka intends to integrate plea bargaining into the criminal justice system, but under strong judicial supervision. The potential benefits for Sri Lanka under this arrangement are substantial. 1. A reduction in case backlog, enabling courts to function more efficiently. 2. Faster trials and reduced pre-trial detention, ensuring that justice is meted out equitably vis-à-vis the accused. 3. Greater efficiency in allocating prosecutorial and judicial resources. And 4. More timely relief and closure for victims. However, plea bargaining is not without risks. One major concern is the possibility of coercion. An accused person, particularly one lacking education or proper legal representation, may feel pressured to plead guilty simply to avoid the risk of a longer sentence after trial, even if they are innocent. A second concern is inequality in bargaining power. The state, with its resources and authority, must not be allowed to dominate the negotiation process. Third issue is transparency. Plea agreements must be recorded and reviewed to prevent arbitrary outcomes and maintain public trust in the justice system. Therefore, the success of the reforms will depend on adequate training, proper funding for legal aid, and strict judicial monitoring. One aspect which is regrettably lacking in Sri Lanka is the formulation of plea bargaining guidelines in order to crystallize the conceptual and jurisprudential underpinnings of plea bargaining, which would have practical and consistent application. In fact, when I was preparing for this presentation, I did get an opportunity of going through certain plea bargaining guidelines issued by some of the other jurisdictions, but due to lack of time, I cannot discuss the provisions which were contained in some of those guidelines. Even countries like Kenya has a very comprehensive set of guidelines. In conclusion, plea bargaining represents both an opportunity and a responsibility for Sri Lanka. If implemented carefully with strong safeguards and judicial oversight, it has the potential to significantly improve the efficiency, effectiveness, and fairness of the criminal justice process. It can reduce delays, ease the burden on courts, and allow the system to focus its resources on the most serious and contested cases. However, if implemented without proper safeguards, it risks compromising the rights of the accused, particularly the vulnerable and unrepresented. Thus, the future of plea bargaining in Sri Lanka must balance efficiency with justice, expediency with fairness, and practical necessity with constitutional integrity. Thank you very much. Sorry if I took more than what was allocated to you.
Thank you so much, sir, for insightful speech. Now I would like to respectfully invite Mr. Salih Piris, President's Council. Mr. Salih Piris will speak strategic planning and making practical application, focusing on areas important for practitioners. I invite you, sir.
Justice Kodagoda, Justice Abhay Surya, Mr. Darshana Kurupu. I will, ladies and gentlemen, I will try to share experiences and perhaps try to, from a defense perspective, point out to you certain things perhaps which you should be mindful in this plea bargaining process. Now, while plea bargaining has always been part of our law, the Court of Appeal in certain cases has said sentence bargaining is not, and said you can bargain for a plea for a lesser charge but not bargain with court in respect of the sentence. Now that case was in the case of AG versus Mendes. What happened was, very briefly, there was a case in the High Court, a case of check fraud in the central bank. And as the trial commenced, the learned High Court judge indicated that, I won't mention the gender, the learned High Court judge indicated that the judge would be willing to accept a plea, and indicated that the judge will give a suspended sentence. In the course of submission, the judge recorded that State Counsel was also agreeable to a suspended sentence. Now, when the case concluded and the file went to the supervising officer did not like that. And the supervising officer decided to go in revision to the Court of Appeal. And the State Counsel, like our proverbial in Sinhala, what you say, Gireta, the State Counsel had to give an affidavit to say that he did not consent. Now, the Court of Appeal said whatever it is, whether the State Counsel consented or not, that the sentence was inadequate, revised the sentence and said there can't be sentence bargaining, and the accused who pleaded guilty on the basis of that they would get a suspended sentence were given a custodial term. A similar case happened in Gampaha, in a rape case, where a suspended sentence was given, the AG went in revision and the court enhanced the sentence. So, in those cases, the court said sentence bargaining is not acceptable. But we know, in practice, sentence bargaining is part of the culture. Many judges, either expressly or impliedly, would indicate the sentence, at least whether it would be a custodial sentence or not, to give the accused a reasonable chance to decide. So now the new amendment really formalizes what has been in existence. So what are the things which you ought to consider in putting in a plea? Firstly, you must remember that it is in the best interest of your client that you must keep in mind, especially if you are a defense counsel, you are considering a plea, what is the best interest of your client. So, whether to put in a plea or not, that is a question which you must decide at a particular stage. The earlier the better. So, for that purpose, you must weigh the final outcome. What could be the possible final outcome of the case? Take a case of murder. Once you have read the brief, once you are familiar with the brief, if you are convinced that this case is going to result in a conviction, but there is a possibility of negotiating a plea bargain for a lesser count, or if it is not murder, if it is any other case even, if you look at the brief and after hearing the story of your client, if you are convinced that going to trial will not serve a useful purpose, then that is the point where you must consider putting in a plea. Very often in appeals, both in the Court of Appeal and in the Supreme Court, we come across cases where a counsel advise their client, or sometimes because the client insists, counsel go into trial without considering a so-called shortcut. So there are cases which have ended up in the death sentence, ended up in conviction, custodial sentences, either because the client insists or because the lawyer counsel does not advise the client properly. And so what does that end up? A case with a potential jail term or a suspended sentence. Case goes into trial, ends up in the client being convicted and being sentenced to death. I would say a good 20 to 30% of the cases in the Court of Appeal could be concluded at the stage of the High Court. But the defense takes a risk of going to trial, and that risk does not succeed, and the client ends up being sentenced to death. Chances in appeal, as you know, to the Court of Appeal, if it is 50, it may be 50-50. In the Supreme Court, chances are very much less. I would say in all appellate, in many countries, the highest court gives leave only in a few cases. So, on a substantial question of law. So, you must assess your case and remember that it is better your client go in for a few years rather than having to face a death sentence with no prospect of release. So, take for instance in a corruption case or in a bribery case. Sometimes the client will come to you and say, I don't want to put in a plea because of my job. I want to secure my job, my salary, my pension. But that versus spending time in jail, the difficulties which the family would have to undergo, all those you have to keep in mind and to advise your client. So, it may be better, even where it is a case where it is a clear case of culpable homicide not amounting to murder, going in for trial might result in a longer sentence. So why risk a higher sentence, a longer sentence in respect of your client when you can put in a plea and get a shorter sentence? Of course, on the other hand, you must also weigh the chances of should you put in a plea. If you go for trial, will your client be acquitted? As a state counsel in the High Court of Negombo, I had this experience. There was a drug case, a 21-year-old accused. When I read the file, I realized there were weaknesses in the investigation. The color of the briefcase where the drugs had come in seemed to be different. The way it was packed was different, so on. So in my mind, I thought this is not going to be a good case. Then the lawyer came in and said, I am putting in a plea. So then I said, very well. I happily, there's nothing to accept. He put in, the accused put in the plea. What was the sentence? Life sentence. So whereas if he went through the trial, there would have been a good prospect of acquittal. So that is something you have to weigh. So then, when to plead? Timing is important. Pre-trial stage would be better. It would be better to put in a plea at the beginning rather than in between. So if you plead guilty before the evidence is placed, it is likely that your client will get a higher concession than if evidence is late. Once evidence is late, perhaps that could affect the mind of a judge. When the judge listens to the evidence, if the victim is giving evidence, then that could obviously affect it. So in a recent case, I advised my client it would be best to put in a plea. But the client was not willing. Then after the evidence was late on the first day, he decided to put in a plea. But naturally, in my belief, if he had put in a plea earlier, there would have been a greater concession given by the court. So timing is of utmost importance, and that is very important for you to consider. Then thirdly, assessing your judge assessing the prosecution. There are judges who are, what we in defense terms say, good for sentencing. There are judges who are not so good for sentencing. There are certain judges, if you go in for trial, the judge will acquit. But if you plead guilty, the judge might impose a custodial term. There was one judge in the High Court of Panadura, she would rarely impose a death sentence. Even the worst of cases, she would somehow make it count and give a custodial term. So you must assess the judge concerned. Also the prosecutor. Again, we have the prosecutors who are hardline prosecutors. You have the more moderate prosecutors. So plea bargaining is that, to assess your prosecutor, right? And sometimes the prosecutor also, who has 10 cases, there are state counsel here, you might like if certain cases end in a plea. They would have less files to read. So those are the practical aspects. You must. So don't go in blindly and plead. You need to assess the judge. As in every case, you know that if a lot of it depends on the judge. Justice Kodaguru, Justice Abesuri are here. And both have been counseled. We all know that we assess the judge before whom we appear. So in the same manner, you do need to assess the court and the prosecutor. Now some client, remember, you have to help your client to take an informed decision. The final decision is that of your client. And you should not pressurize your client. Of course, you can persuade him, you can show him the pros and cons, but the ultimate decision is that of the client. Many years ago, I appeared in appeal for a young, for 2 or 3 young professionals. They had been charged under the charge for stock exchange fraud. They were facing indictment before a particular tough High Court judge. They were defended by one of the 3 most eminent criminal counsel of the day, criminal trial counsel at that time. The judge had asked in open court, will they put in a plea? The President's counsel turned to his client and said, put in a plea. So they immediately they agreed. In the well of the court, they agreed. The charges were read. They were each sentenced to 5 years rigorous imprisonment. Fortunately, so they appealed. They got bail pending appeal. The Court of Appeal suspended the sentence. But that is not helping your client to take an informed decision. You must allow your client to take an informed decision. The pros and cons, that if he goes in, that there might be a custodial term, so that is absolutely important. And what you ought to do is to guide your client to take that informed decision. I will finally end up with, so the new Procedure Code amendment gives us a framework to do that negotiation. And that would most certainly be of benefit to all parties concerned. I will just end my speech with another story which I think the justices here also ought to hear. There was a case in the High Court of Canada, multiple cases where there had been abuse in a temple. And there were several accused, all in their late teens. And I think one of the priests in the temple. Multiple cases. The High Court judge indicated that he would give a non-custodial sentence. So the accused all pleaded guilty. The High Court judge gave a suspended sentence. Now the files went to differ, or probably may have gone to the same supervising office in the AG's department. The AG went in revision in some of the cases, but not all. Finally, in one case, the Court of Appeal enhanced the sentence from suspended to 10 years. But in another case, the AG withdrew the revision application. And in some cases, the AG did not proceed. Now, this one man who was given, whose sentence was enhanced, was on bail. He was on bail. He appealed to by way of special leave, he went to the Supreme Court. The Supreme Court reduced the sentence from 10 years to 7 years. He never surrendered. He never surrendered. But he keeps on asking the question, how is it that my sentence was enhanced, but other people, including that of the main accused, who was a priest, how is it that they got suspended sentences and went home? So I really had to have no question. He calls, his mother calls. So I tell them that nothing which can be done, the Supreme Court is well. I said, try to ask the president for a pardon. I mean, I know it won't happen, but that was all I could say. But I have no answer to give him when he asked, why did this happen to me? Thank you.
Thank you very much, sir, for sharing your experience. And this is our purpose also, educate as to how we implement this new amendment. So I would like to now invite His Lordship Justice Jasantha Kodagoda to speak on judicial oversight in plea bargaining, balancing out the pros and cons. Sir, over to you.
Thank you, Darshana. Ladies and gentlemen, what appears to be standing in the way between your getting back to the room and engaging in various preparations, painting, etc. for the gala dinner, and now is my speech. So I would assume that you would want me to keep it very short. Ladies and gentlemen, in the 52 high courts spread throughout the country, exercising original criminal jurisdiction, there are approximately 35,000 cases on indictment. If all of these cases are to proceed to trial and end, there will in fact be no end, because by that time further indictments would come and the backlog would increase. And therefore, a reasonable way forward would be to explore this new avenue that is now available. As Mr. Piri said, there is now, unlike in the past, a structured, a formal system for plea negotiations. Basically, what happens in a plea negotiation is for one out of the two parties to take the initiative. So either the defense counsel or the prosecutor will indicate to the other that he is willing to negotiate on the sentence to be imposed on the understanding that the accused would plead guilty. In terms of this law, there is provision for the High Court judge himself to take the initiative and suggest to the two counsel that they engage in a plea negotiation. So assume that the High Court judge does not take the initiative. It is up to either the prosecutor or to the defense counsel to indicate his hand and start the negotiation process. If a defense counsel were to take that initiative, it is unlikely that the prosecutor would be opposed to it, because he would also quite naturally want the matter to come to an end as expeditiously as possible. What might be the criteria that counsel would apply in this regard? So there is the sentence option, which is available on the face of the statute. Some statutes for certain offences carry a minimum mandatory term of imprisonment. Then plea negotiations is going to be a little difficult and not impossible. And on the other hand, there would be the 0 to the maximum scenario where there is no minimum mandatory term of imprisonment. The second category of cases make plea bargaining easier, because it is likely that the starting point of any defense counsel would be the expectation of a suspended term of imprisonment on the basis that the accused is pleading at the first available opportunity. Now, what are the carrots that you can throw onto the table in order to extract agreement from the prosecutor. That is actually what you need to consider. From a prosecutor's perspective, the weaker his case is, the more likely that he will be amenable to a negotiated outcome, and even agreeing to suggest and propose to the judge that a suspended term of imprisonment be given. The weakness, which will partly depend on the availability or otherwise of witnesses, some of whom may not be available, some may have passed away, documentary evidence and real evidence, and the overall strength of the case. So a defense counsel can easily meet the prosecutor in chambers, explain to him from his perspective why he submits that the case for the prosecution is a weak case. And particularly, those of you who work in the High Court on both sides of the table would know that as time lapses, with the passage of time, cases don't become strong, they simply become weak due to multiple reasons. So the age of the case is also to be a factor. And the Court of Appeal has in a couple of cases said that if an accused has been on bail for 10 years or more without violating a condition of bail, it would be undesirable in the first instance to put the man back in prison. That it will be undesirable from a public policy perspective, and that is also something that you can take into consideration. And also the conventional discount that is given to any accused who pleads guilty at the first available opportunity. There are some more strategic advantages that you can make use of. For example, in terms of the statute, not only can you advance matters that are directly relevant to the case, you can cite collateral factors such as the accused's willingness to cooperate with investigators and provide information about other accused who may be involved in crime. So that type of additional factor can also be made use of. And prosecutors must also bear in mind that a negotiation can't be a one-way house. It is a case of the two parties reaching optimal satisfaction of their respective interests. So prosecutors also shouldn't start the negotiation and proceed with it on the footing that he or she must also have what I would say his or her pound of flesh. There has to be a negotiated outcome, which means coming to the center as far as it is reasonably possible. Now, should you reach agreement, the matter has to be presented in that draft form to the trial judge for, as it was said, for judicial oversight and endorsement. And then the judge will also indicate his mind very openly as to the appropriateness or otherwise of the sentence to be imposed. He might even say, though the prosecutor has agreed with you for a term of imprisonment of 1 year or for a suspended term, that in his view it is inadequate. He might say that. Another negotiating factor that you can use is that you're willing to provide an X amount of compensation to the victim of crime or to the state in consideration for the granting of a suspended term of imprisonment. That is also possible. Be that as it may, if notwithstanding agreement between the prosecutor and the defense counsel, the trial judge expresses a different view, the accused has the entitlement in terms of this law to withdraw his willingness to plead guilty. He can say, let's go in for trial. But what is the flip side consequence of that? Prosecutor and the defense counsel, they have engaged in negotiations, they have reached agreement. They go before the judge takes a different view of the matter. Now the plea is not successful. Accused is entitled to backtrack, withdraw, and say, let's go to trial. I'm not going to plead guilty. From a rights perspective, that is all and good. But look at it from a strategic perspective. Through this process, the accused has indicated his willingness to plead guilty. That is going to operate in the mind of the trial judge throughout. That this person cannot be an innocent person who has been falsely accused by the Attorney General. So that is going to then cause considerable prejudice in the mind of the trial judge. And that operates against the interest of the accused who has now decided to go back. If so, ladies and gentlemen, what is the way forward? The way forward, I would suggest, is for the judiciary to announce sentencing policies and guidelines, as it is found in many other countries, where there are gazetted policies and guidelines that will indicate the approach to be taken by a trial judge when determining the sentence. Secondly, for the Attorney General to announce criteria based upon which the Attorney General will be amenable to a lesser sentence, or at the rock bottom to a suspended term of imprisonment. Those two, I think, would be necessary to make this happen. Thirdly, I think it is best that pre-trial judicial oversight of plea negotiations take place not before the trial judge, but before another trial judge. Now, in terms of the Judicature Act, for both criminal and civil trials, there is provision for the appointment of recorders and masters. Recorders for civil trials, district court cases, and masters for high court cases. For what purpose? For the purpose of attending to pre-trial and post-trial matters outside open court in their respective chambers. Now, if that mechanism can be activated, the pre-trial conference, which is an ideal moment for the plea negotiation to take place, as well as judicial oversight of the appropriateness of the agreed sentence, can take place before the master, who is not the trial judge. He maintains a separate docket and he goes into the matter and indicates his mind. That can easily happen if only we give effect to the existing law, that is by appointing masters and recorders for criminal and civil matters. Then that element of prejudice that can arise due to a failed plea negotiation can be eliminated. So these are some of my initial thoughts. As I indicated, it is best that we allow you to get your respective rooms and get ready for what is in store, whatever that might be. Mr. Veeragoda. Thank you very much, ladies and gentlemen.
I would like, since the speeches are over,
Now we will open the floor for questions and answers. So if you have any question, your microphone will be handed over so you can ask. Yes.
Where the investigation had been done in a manner which is undesirable, so to say. In such a situation where it's only in trial that sometimes we find, during cross-examination, for example, that we find that the document has been manipulated. So in that system, having a plea bargaining system implemented where the prosecution also may be misled, or in a system where we think that, okay, this is a borderline case, so let them get out because you are presumed to be innocent until proven guilty, let them sort it out in court sort of mentality. Would a plea bargaining system really achieve its true purpose?
I think Justice Kodak will answer that.
As I see, Fisher, in such a situation where the criminal defense attorney receives instructions from his client that the investigation was unfair, that he has been framed, and that he is innocent as the blue moon, which I think is what almost all accused start with by saying, then you need not initiate the process. It's a case of just remaining silent and facing the trial. You initiate the process from a defense perspective only because you are attracted to that inherent discount of a minimum sentence in the event of pleading guilty at the first available opportunity. So there is no compulsion, and in fact in terms of the law there should not be any compulsion either, but there are attractions. The main attraction is the discounted sentence. Other attractions can be Mr. Salih Piris may not charge so much for tendering a plea as opposed to facing a protracted trial, and also the cumbersome nature of a trial by itself. And I must tell you, there are two other options that are available which we ought to look at very progressively. One is to empower the Attorney General to suspend the institution of criminal proceedings based on certain criteria. Once again, an amendment is required. And the other is deferred prosecution agreements, particularly against corporate accused. Without adopting some of these new measures that the developed world has already adopted, and maybe we are about 15 years behind in that regard, I must tell you there is absolutely no sustainable method of clearing the backlog. Yes, you can apply some degree of pressure on the judges. Judges can apply pressure on counsel, but is it sustainable in the long term? Would it in fact give rise to desired outcomes in the long term is something that we need to very seriously consider. Thank you.
If I may add to what His Lordship said. Now, in my presentation, I referred to the fact that the law, law meaning that is Act number 50 of 2024, the Code of Criminal Procedure Amendment Act, provides for a particular format to be used. And that format is called Form 23. It is in this particular form or this format that the plea agreement will be crystallized. And the last paragraph or the last part of this particular format, I think, provides the answer to the question you posed to the panel, because the accused has to place his signature, and he has also got to write the date. Now, just above the place where the accused has to place the signature, there is a paragraph. And one part of the paragraph, if I may be permitted to read, states that I understand I do this knowingly, freely, and voluntarily, and without any threat, force, intimidation, or coercion of any kind. So it is only after the accused have read this last paragraph that he is expected to place his signature. I think the drafters of this law has definitely taken on board concerns you expressed, and that is why this particular format, or this in the form, there is this particular paragraph. Thank you.
Any other question? I think trial judge should make sure that the plea is voluntary. And is there any other question from the audience? If not, I have a question. So, since this amendment formalizes plea bargaining through section 183A and 197A, Your Lordship, Justice Kodagada, do you think this act is fully compatible with Article 30 of the Constitution? Because accused has to waive his right to a trial, cross-examination, and even he has to waive his right to an appeal.
Darshana, I take a different view, because there is absolutely no compulsion in terms of the new law to tender a plea. He can just remain silent and face a full-fledged trial, or maybe defer taking a decision to a midpoint in the trial. So there is nothing that operates against the right to remain silent or the presumption of innocence. This would be my view. I don't know, Salia, what might be your views?
Yeah, I think, I also don't think it is incompatible with a fair trial. A part of a fair trial is to give if the accused wants to put in a plea. I think basically what this law does is to introduce a framework. Earlier it was all over the place, but now you have a framework, so there is some consistency. Perhaps, as Justice Abesurya mentioned, if there are guidelines, and Justice Kodagoda mentioned, if there are guidelines, sentencing guidelines also, there would be greater consistency, because I think something which we face is in both the magistrates' courts and the high courts, there is somewhat a lack of consistency between judges and between courts. So that is why we know there are tougher, so-called tougher, more difficult judges, more lenient judges. So there is always that tension. But if there are sentencing guidelines, I think it would become clearer what would be of course, I don't think you can take away discretion totally, but there might be some degree of consistency.
Thank you, sir. Thank you very much. Sir, I have a question. Now, assuming judge doesn't want to accept the plea agreement. He says, no, I can't accept the plea agreement. What is the right of the accused has? Can the accused challenge the decision of the trial judge?
Darshan, he can't challenge that decision, but he can always withdraw from the plea arrangement and face a full-fledged trial. Thereafter, if he is convicted and an inappropriate sentence is imposed, he can maybe raise it in appeal, that this is a case where there was an initial willingness to plead guilty, but because of this particular situation that you referred to, he had to resile from the negotiation process.
Just to once again add to what His Lordship stated, I believe what Darshana meant was if the parties are willing, but the judge on his own ex mere moto decides not to permit the plea bargaining process to go ahead, what would be the consequences? in my view, I think the answer lies in section 14 of the Act number 50 of 2024, because the judge arbitrarily and capriciously cannot just inform the parties, no, I'm not going to allow you to enter into a plea agreement, because that section clearly says the reason, if the judge were to reject it, the reasons for such rejection shall be recorded and the parties shall be informed thereof. So it's not only recording, the parties will have to be informed by the learned trial judge as to the reasons why he is not permitting the plea agreement to go ahead. So there are, I think, inbuilt safeguards contained in this particular enactment. Thank you.
As a concluding thought, Darshana, can I say, if this is to work, I think Attorney General and his prosecutors must show their willingness to adopt this mechanism and announce criteria based upon which the AG will be amenable to a lesser or a minimal sentence. That is, I think, essential. Otherwise, from a typical criminal defense perspective, no defense counsel would suggest to his client that they initiate the process.
Certainly. Thank you very much. We hope that today's we had a discussion and with great discussion and practical guidance for juniors and practitioners, while also encouraging ongoing reflection on how we can uphold justice and protect the rights of all parties involved in legal framework. Once again, thank you all for contributing a very engaging and enlightening discussion. Thank you very much, sir. Thank you.
With that, ladies and gentlemen, I think we are reaching the conclusion of this session. Let me extend my sincere gratitude to all our esteemed panelists. Let me invite Satisha Vedagoda, Attorney at Law, to present tokens of appreciation to Honorable Justice Yasantha Kodagoda, President's Counsel, for his invaluable insights, to Honorable Justice Mohanta Abhisuriya, President's Counsel, for his thoughtful contributions, and to Mr. Salih Piri's President's Counsel for sharing his expertise with us today. We also extend a heartfelt thanks to and a token of appreciation to our moderator, Mr. Darshana Kuruppu, Attorney at Law, for skillfully guiding this discussion. Thank you for all your valuable time, wisdom and commitment to furthering the understanding of criminal justice in Sri Lanka. Good evening.